All right, good morning, everyone. Why don't we go ahead and get started? Before we take roll call, let's have anybody who's on the phone identify themselves. I think we have at least Justin.
Yeah, good morning. Justin's here.
Morning, Justin. I'll just quickly say congratulations as well. Justin's attending my phone. He has a new baby, so congratulations.
Yay, congratulations.
Thank you very much. Glad I could still make it. At least my phone.
We are too. Thank you. All right, anybody else on the phone? Okay, why don't we go ahead and take roll call then?
Okay. Andrew Dilworth,
Here.
Amy Clumsy,
Here.
Kendra Basner,
Here.
Stephen Bundy, Suzanne Burke Spencer, Eric Deitz,
Here.
Justin Fields,
Here.
Matthew Hodel, Joel Osmond,
Here.
Marla Richardson, Dina Roche,
Here.
Teresa Schmid,
Here.
Ujjvala Singh,
Here.
Richard Solomon, Dr. Stephen Sparta,
Here.
Marshall Whitney.
Here.
Thank you.
Oh, we did?
Yeah.
Yeah, sure, that's great.
All right. Anything on staff report?
Yes. Before we begin, just a friendly reminder, there are no microphones this morning, and as we're all aware, we're being webcast, so coming from someone who speaks low and mumbles himself, I encourage everybody to speak with a full voice when we talk today, just so everything can be captured, and of course, so Justin can hear us as well on the telephone. I also want to introduce Donna Hershkowitz, who's here joining our meeting today. Donna is the State Bar's Chief of Programs, and so she oversees 7 departments at the bar. This was part of the bar's reorganization efforts that took place last year, and Donna oversees the Office of Professional Competence as part of that role. I think many of you are aware, me and myself report to Randy DeFantorum, who's the managing, the program manager of our department. Randy now reports to Donna, and Donna reports to Leah Wilson, the executive director at the bar. Just by way of background, the Office of Professional Competence used to report from anyone to the Office of General Counsel, to directly the executive director in years past, and now we have a better, more streamlined organization structure than the bar, and part of that is Donna's role in overseeing our department. She's here to get a better feel and understanding of the committee's work, because the committee is obviously staffed by us here in the Office of Professional Competence. So please welcome Donna, and if you have any questions for me or her, we're all approachable, so don't hesitate to ask. Going to the work of the committee, your opinion 14-0003 is circulating for a 90-day public comment. That's the opinion we voted out at the last meeting. The deadline for that opinion is May the 3rd. The drafting team we've received 1 public comment. I forwarded it to the drafting team. Drew may speak to that once we get the meeting formally underway, but just want to let you know that opinion is currently circulating for public comment with a May 3rd deadline. The application deadline for members to apply to this committee has passed. That was Monday, February 5th or 6th, if I recall my dates correctly. As of today, we've received 7 applicants, including 1 public member. We will have a public member vacancy next year, so that's a big plus. But this is a little bit lower applicant pool than we've had in years past. If there's someone you personally knew was interested in applying, may not submit their application, we can exercise some discretion and receive a late application, but let me know if that's the case, especially true when it's a low applicant pool. Yes, Mr. Osmond.
I've had a conversation with a member of my firm. I'm in my 3rd year. I may not be around next year. I think it's likely I will not. How do you feel about someone who feels vaguely nepotistic? Nepotism. How do you feel about somebody from the same firm applying that's still a member on on this?
So there is a State Bar Board Book rule on that in terms of multiple members from the same firm serving at the same time. That is generally discouraged. Exceptions can be made in certain circumstances, but it's generally discouraged because you would be cycling off. That issue, may not present itself, but we can talk about that. And if it doesn't work out this year, of course, in the future, as I say frequently at these meetings, those of you who practice in this area are the ones who can really identify strong members. And your experience on the committee, you know what it takes to be a productive member of the committee. And the strength of the committee really relies on people such as yourselves being able to identify appropriate and strong candidates. So I definitely encourage that whenever you know of such persons.
So, Andrew,
Can I just, also,
I was just going to say, so it sounds like the discouragement is the concurrent.
That's correct.
The sequential is less of an issue, it sounds like, is that?
That's correct. That's correct.
so, and so in the situation Joel's presenting, assuming that Joel does not continue on, it would be fine for one of his colleagues to
Yeah,
apply.
Yes.
I mean,
No one is
especially given the small pool is here.
No one is precluded from applying, so you can always apply. Now, if we are weighing people to appoint, and someone was on the committee at the same time as another member of the firm, that would become an issue. But yes, if he's no longer on the committee, then absolutely anyone can apply. I don't want to discourage anyone from the opportunity to apply.
Right, and I mean, in fact, we want to encourage.
Exactly.
Yeah.
Yeah.
The more
And,
applicants, the better.
and your firm is, Joel's firm
Well,
is.
my firm has sort of this history.
Right.
I've also had a conversation with one of Suzanne's partners who asked a similar question.
Well, we know Suzanne's not going to be
We know Suzanne's not going to be here.
there. Okay.
Right. Now, the only other caveat I'd state is we would need that application ASAP, because the next statement is we got the application nomination committee is going to start scheduling interviews for these individuals. It will be at our June 8th meeting that the slate of nominees will be presented to the full committee, in which this committee will take a vote to approve those applicants to serve on the committee. The applicants are still need to be confirmed by the Board of Trustees. And yes,
Can you remind us how many slots we'll be filling in this next?
there'll be
cycle?
3 attorney openings and 1 public member spot. So we'll be filling a total of 4 people. And we also need to identify the vice chair for next year. And the internal committee rules are you'll be receiving, state that after April 1st, staff sends an email to the entire committee, but it's available for second and third year members to nominate themselves to run for vice chair. If there's more than one applicant for the position, we will hold an election during the June 8th meeting, and at the June 8th meeting, we both confirm the vice chair and the 3 or the 4 applicants we wish to appoint to the committee for next year. Any questions about that? Yes.
Well, not about that per se, but one further question in terms of the applicants, without getting into the details of the people that have already applied. A question that's come up before and might be worth just clarifying is, what about applicants who were previously on COBRAC?
Yes.
Saw that one of the current applicants is someone who's been on the committee in the past.
Correct. So we have had people, it's similar, it's a little distinct from, but similar to the concurrent appointment from the same firm. So, if we have if you have a handful of applicants who are all strong, one of whom has already served, well, the deference is going to be to the people who have not yet served on the committee. But if you have a thin applicant pool, or an applicant pool with people with less relevant background or experience, and one of the applicants is someone who has served, staff can and has in years past written a memo, a short memo to the board stating why reappointment of a member who had previously served is warranted in this year.
Is there a precedent on COPRAC specifically for that? Has there been COPRAC members that serve more than one?
Yeah.
Yes.
Okay.
Harry Sondheim is the most famous one. He served as chair twice. Now, a good example of that, his second appointment to the committee, he applied multiple years in a row. So the first year he applied was a strong applicant pool year. Those that were applying that had not been on the committee were qualified candidates. Mr. Sondheim was not appointed that year. He applied again. I don't know if it was the second or third year after the first year in which he was not appointed for the second time. And one of those years, the stars aligned in that it was a weak applicant pool. I think he had criminal background experience as well. For a variety of reasons, he was appointed. So it is not unheard of, and frankly, maybe necessary based on the pool of applicants we've been getting in recent years, that people who have served on the committee, may be appointed again going forward.
It sounds to me like, from our perspective, the more people that apply, the better, right?
Absolutely.
Just be encouraging anybody that wants to apply.
It is like any organization. It's like Harvard. You want, everybody with all the 4.4 GPAs to apply, and then you can choose the best of those applicants. Any other questions? Okay. My last report of a long staff report today is on the request for a new rule of professional conduct that was received by the San Francisco District Attorney. As you're well aware, this committee worked very diligently in 2 meetings to create a report and recommendation concerning that request, and it was placed on the January board meeting for consideration. And after the item was placed on the board meeting, the board agenda, the San Francisco District Attorney, George Gascon, submitted a letter to the board president saying that, in so many words, he's not stuck on a rule of professional conduct per se. He'd be interested in solving this issue either through a rule, through a statute, through a rule of court, and would like to work more closely or get some more input from the State Bar in terms of how to achieve that. And upon receiving that letter, the chair of the board withdrew the agenda item from the meeting, so the rule wasn't discussed because they didn't want to preclude the rule option after receiving this letter from the district attorney. The State Bar will be in contact with the requester, the San Francisco District Attorney's Office, in terms of seeing how best the State Bar can assist Mr. Gascon in whatever way he wants to achieve his goal here, protecting undocumented immigrants and their ability to participate in the judicial process. So that's the latest on that.
Andrew, is there any way you could circulate that letter to us? Because there might be things we hadn't thought about.
Sure.
In the letter. It's just, are you okay with that?
Sure.
Yeah, I can see if I can get that. Yeah.
Thank you very much. Appreciate it.
No problem.
And I guess from our perspective as a committee, we're sort of in a holding pattern, right? In terms of whether the board, they may come back and ask for some further assistance, they may not. We're just sort of waiting to see what they're going to.
Exactly. So we are not cut loose. A rule is not being pursued at this time, but that's not to say it won't be in the future, and your help and assistance won't be needed in the future. Just as of right now, they didn't.
Weighing their options.
Yeah, with the pending legislation and receipt of Mr. Gascon's letter, pursuing a rule without seeing what develops first in terms of other avenues. I'm only hesitating because I want to speak for, I didn't have a conversation with the chair of the board, so I know exactly what I was thinking. It's just my assumption. He didn't want, he probably thought it wasn't it was prudent to wait to see how best to assist with the rule request.
Do you happen to know if they got any additional input besides Mr. Gaskell? I mean, I'm just wondering if, they got input from the public defenders or somebody like that.
Not that I'm aware of. Not through the bar.
Okay.
Now, as we know, Senator Wiener's office is the sponsor of the legislation. And so I don't know, what stakeholders that office is in communication with, but in terms of the bar, as far as I'm aware, we didn't receive any other input. Okay. Any questions for staff? All right. Back to you.
All right. Well, before we get to the opinions, Andrew referenced the fact that there had been a comment that came in on 0003, and it's kind of early in terms of the deadline, but it was late in terms of our materials going out, so I think a lot of people didn't get it in advance of this meeting. I thought I'd just cover it really quickly. It's pretty short. It's from an individual named Cameron Moskahim, and he seems to be in favor of the opinion. I'll read what he said. It's very short, but just so you guys know, it says, "Thank you for sending the opinion. I don't know how often you receive public comments. The only comment I could make is this. Although it is a rare case that the facts upon which an action was commenced turned out to be completely false, the proposed opinion being limited to that fact pattern, or limited to that fact pattern stated, adequately identifies and discusses the relevant rules and their intended obligations." So, I mean, the only sort of substance I take from that is his comment that, maybe it's not all that common to have a scenario where the case is totally devoid of merit. I don't think that alters anything with respect to the opinion, because the whole thrust of the opinion, which is based on, one of the court cases that we cite, is in this scenario where the lawyer has a case where the lawyer's convinced there is no merit, can you potentially settle the case as opposed to simply withdrawing? So that's kind of a core component of the opinion's factual backdrop, again, keying off of an unanswered question from California courts. And I think the opinion is instructive even beyond those specific facts. But that was his comment. Again, I think it's a favorable comment, but I just thought I would read it to everybody because I don't think people had a chance to receive it in advance of this meeting. And I think, May 3rd is the deadline, right, Andrew? So we may well be receiving more comments on this opinion as we get closer to the deadline.
Yeah.
All right. So I'm going to take opinions sort of out of order today. We have some timing issues for different people. But before we do that, we do need to approve our action summary from the January 12th meeting. And so that was in your materials. And if you haven't already looked at it, feel free to take a moment to review it. But if there's anybody who has a motion to approve that summary or has any comments on it, let me know. Let's address the move to approve. Sorry.
All right. Andrew Dilworth,
Yes.
Amy Bomsey,
Yes.
Kendra Basma,
Yes.
Stephen Bundy,
Yes.
Eric Dietz,
Yes.
Justin Fields,
Yes.
Matthew Hodel, Joel Osmond,
Yes.
Marlo Richardson, Dina Roche,
Yes.
Teresa Schmidt,
Yes.
Ujjwala Singh,
Abstain, I wasn't here last time.
okay, Richard Solomon, Dr. Stephen Sparta,
Abstain.
Marshall Whitney.
Abstain, I wasn't here.
Thank you.
All right. So moving to the opinions, Stephen, when getting settled, can we do the ancillary business? Absolutely. Whenever you're ready. All right, let's do that, and then I think after that we'll do the impaired colleague. No, Eric, no timing issue. We'll move on from there, but let's start with 16003.
16003.
Okay. I want to say that the comments last time were incredibly helpful, and I think last time we talked about this was in December. And I've tried to respond to them. And some of this is just sort of simplifying. I limited the number of, I dropped some of the businesses that seemed to present more difficult analytic issues or didn't add much in terms of analytic issues. And what's left is that one of the businesses is a fiduciary business and the other isn't, which is arguably important in terms of the way the law is developed in California. I did add a brief footnote discussing Lee versus Hanley, which several people thought, mainly just to try to take it out of play, because I don't think we want to get into the statute of limitations issues. I tried to beef up the rationale for bringing in Model Rule 5, portions of Model Rule 5.7. Pardon? Sorry, do you want to, should I turn on?
We don't have a microphone.
We don't today.
So you
Oh, okay.
Yeah, yeah.
I'll go in classroom.
You gotta dig deep.
How's that?
You gotta dig deep.
Professor voice.
Yeah, no, exactly. I'll set it at 11 on that. Anyway, so a couple of people had mentioned, we should be clear on why it is we think that 5.7 is even an appropriate subject of reference. And so I tried to link the use of 5.7 to our standards for looking to other states' authority. I wanted to give, several people said, well, there's not much in here on what counts as a non-legal business, particularly a non-legal business that might be subject to the rules of professional conduct because it looks like law. And I did what I could with the cases. There isn't that much thinking in the case law. And then suggested, and this is something we may want to talk about, looked to Model Rule 5.7 at that point for a suggestion of the range of kinds of things that might trigger that sort of concern. I think the biggest substantive change in the opinion is to really spell out the idea that you can disclaim in this kind of situation. That even though the business is one that the state, that the authorities say could be treated as subject to the rules of professional conduct, that if you're engaged in that business and you have done appropriate disclaimers to make clear that you're not practicing law, not forming a lawyer-client relationship, and so forth, and that's been done in a way that a reasonable customer should understand, right? Then, and sophisticated customers are obviously going to understand more than unsophisticated customers. Then you can proceed under the regulatory regime that applies to the non-law business without worrying about the rules of professional conduct. And that's not anywhere in California law expressly right now. It is a key point in Model Rule 5.7. I think it is in fact how lawyers deal with this issue, right? It's in fact the strategy that's used. If you look, for example, on the Littler Mendelsohn website for their marvelous, complicated legal advice software, the way that they deal with it is by saying, we're not practicing law here, we're not giving legal advice, you don't have a lawyer-client relationship. If you're somebody who doesn't have a lawyer yourself, you should get one to use this software. It's sort of layer after layer of belt and suspenders, and clearly that's a way of trying to do a 5.7 kind of disclaimer move. And so what I tried to do here is to suggest that that's really consistent with the way we think about lawyer-client relationships more generally. So that's the biggest move. And then, now I just realized I need my glasses because I can't even read my own notes. Okay. Then in the sort of back discussion, from the beginning, a number of people have felt, notably Mary, whose idea this opinion was, have felt that we should go over these issues about referrals, conflict of interest, lawyer-client business transactions, and so forth and so on. So I've made some changes at the back in response to discussion to clarify the limits of solicitation, to expand the discussion of conflict of interest in a way that's consistent with Marshall's comments last time about sort of an all things considered perspective balancing. And then I've expanded the discussion of Rule 3300. Now, I want to flag, and Amy, you undoubtedly noticed this, is that the discussion of conflict of interest in 3300 needs to be synced in some ways, or we need to think of it in connection with the issues that you've discussed in your litigation financing opinion. They're very similar, very parallel. That's what I got, and I'm open to suggestions for changes, improvements, et cetera, et cetera.
Great. So I guess we'll start with the subcommittee, which is Amy, myself, and Suzanne. Suzanne is not going to be here today. She has a deposition and wasn't able to be changed. So, Amy, any comments? Or I'll go ahead.
I do, but go ahead.
Okay.
I'll follow you.
Sure. I guess one comment I have just conceptually, I sort of said it before, but to me, one of the most challenging circumstances, situations for this issue is what happens if you actually are providing legal services to a client with respect to a matter, and you wanted to potentially have them use services that were separate and distinct from your legal activities. So you have, your law firm and what you do in terms of legal services. You have investment in a separate entity or some relationship to a separate entity that provides not legal services, but definitely sort of law-related services. And that's still, in my mind, that's the most challenging scenario. Because if you're not providing the legal services, but someone's potentially going to a law-related entity that you have an interest in, that's less problematic. And it's in here in Steve's discussion. But I think one of the biggest questions people are going to have in their mind is, does the disclaimer potentially, disclaimers and a sophisticated client and sort of separation of these different services, legal services and law-related services over here, if there's a relationship with the lawyer that is legal services, is there any possibility of that client being able to use law-related services, in conjunction with that matter?
That are not subject to the rules.
That are not subject to the rules of professional conduct, exactly.
Even though it's in
I
the
mean,
same,
the legal
even though
service-
it's in the same matter.
Right, the legal services of the lawyer obviously would be subject to the rules of professional conduct, but if there's a true distinction, maybe it's a different physical location, different staff, et cetera, and the services of that entity are truly law-related services, is there the potential that that client could utilize or be directed to, with appropriate disclosures and everything else, the use of the services, the law-related services from that separate entity. And I just think that's going to be, to me, that's the hardest, and it's the one that gets closest to, sort of all these fact-specific issues about how sophisticated is the client, how separate is that entity, how clear is it made to the user of those services that those services with that entity are not part of an attorney-client relationship, that they're not going to be confidential, et cetera. I think when I read the whole opinion, that there's a suggestion that may be possible.
I think there is a suggestion that may be possible.
I mean, it's not, we're not saying that it can always
But we're
be-
not saying, I
Right.
would certainly think there's plenty of material for saying it's not possible.
Right, and so
As well.
I guess one observation I had is on the front, we kind of lay out the backdrop here.
Yeah.
And then we get into the discussion, and we raise the disclaimer issue, and we get into the ADA rule.
Yeah.
And by the time you get to the end, my reading of it is it's sort of like it may that in that scenario it may be possible, but you know, you're probably going to have a very sophisticated client. You're going to have to have real distinction of the
Very clear, yeah, exactly.
et cetera. And the only thing I wonder is up front with the discussion, it sounds much more definitive, like you can't do it. And so I just, for a reader who's not immersed in it as much as we are, I read some of the things in the front and they just seem so definitive, saying, you know, this would, you know, the rules would apply here or something. I'm just wondering if maybe on the front end, given the conclusion on the back end, we need to qualify the language a little bit.
It's tricky, isn't it? And
Well, yeah, and I saw it. I mean,
yeah, it's a really good question, and I think I don't have a clear answer in my head. I think I have a kind of an independence answer. You know, part of what's and it's also part of the problem is that the California law on this is written without any thought about disclaimers, right? So it's all written so definitively, right? As this is how it goes. Of course, none of the cases are disclaimer cases. In fact, they're typically cases, as I think I point out at some point in the opinion, they're typically cases where the lawyer was at pains not to distinguish.
right. Yeah, I mean,
between the two businesses, and where there was clear confusion as to what role the lawyer was playing. So it's tricky then to introduce this idea of disclaiming, right? It seems to almost, you're right, because the earlier cases present this as so definitive. I'm not quite sure how to deal with that, but I think it's, I guess the last thing I'd say is, another issue that has struck me as relevant here is, and we don't talk about it in the opinion, is supervision. You know, even if you're not, right, it's very clear that even if you are not, even if the lawyer is dealing with a non-legal business, whether or not it's a non-legal business in which he or she has an interest, right? There's an obligation, if it's part of the representation, to make sure that they comply, right?
I think like the outsourcing.
The outsourcing opinion is totally, or the data opinions, are all full of this duty to supervise, right? So you know, it's hard to imagine a situation where the law firm doesn't end up having some obligation under the professional rules for how it behaves, how that organization behaves, whether it's that the organization is independently subject to the rules, or there's a duty to supervise. I'm not quite sure. You know, I think part of my difficulty is I'm not quite sure how thin to slice the salami. Well, because we're doing quite a lot of new work here, just by introducing the idea of disclaimers in a coherent way.
What are the cases that have found non-liability and separateness relied on? I didn't get a sense that there's any kind of analytic. I haven't read the cases, so I have to apologize. But is there some sort of policy or analysis they go through where they say it's easy to separate? Because when you have a dedicated, captured, non-lawyer functioning entity, you almost look into issues like negligent referral, scope of responsibility. You can waive as a lawyer the scope issues and say, I'm only going to do this, this, and this, but you can't waive negligent overrules. And so when you have these disclaimers, like 5.7 would recognize, when does it go into trying to disclaim responsibility at all? And really a standard care disclaimer versus I'm not doing this, this is somebody independent, when you're not independent. I don't know if the cases have really talked about.
There's so little discussion. It's such a good question. I mean, the idea of separateness, right, is, well, as I've worked on it, here's one of the things that I keep thinking about separateness. It's mostly implied, right? Because about the only thing that the opinions have actually said, right, is not is a restaurant or a dry cleaning business. The only things they've ever said are really clearly not subject. And I thought about that for a long time, and I kept thinking, well, you know, actually, when I was in a law firm, there was a cafeteria in the firm. Firm clients came there. And I thought to myself, oh my God, well, is that part of the pride? But you know, I think you've got to instruct everybody who works in that cafeteria about the rules of professional conduct.
Well,
and at least about confident of a keep your mouth shut. Whatever nothing you hear goes anywhere. Anyway, I'm just saying that I don't have good authority for the proposition that separateness.
but if you look at what would separate that from, I had a client, Los Angeles firm, that had their own in-house process server, and they owned a court reporting.
Right.
And if there were problems with service or problems with the record, I told them, number one, you have to disclose that you own these companies. And number two, yeah, you're on the hook. But that's easy because they are all related to.
And arguably that's part of the practice of law, right?
Those are the extremes. So trying to find out where they come together is.
There's no good authority.
And a lot of it's opinions to his answer too. There just aren't good cases that
It's
rational.
It's a great context for bad facts could make bad law.
Absolutely. I don't have a good, this opinion puts out a lot of what I think is common sense, right? That isn't actually reflected that isn't spelled out anywhere in anything.
It would be wonderful if this so-called independent business test had something to do with, is there any chance or probability that the work this independent business is doing will affect the legal rights or obligations of your client to whom you owe fiduciary duties? If they would give you some sort of test like that, it'd be helpful. Then you could see how it's applied, but no court has done that, I think.
Well, I think that's something we should think about. The question of what it means to be distinct, right? There may be a way to work that concept in, right, to what it means to be distinct. I'd like to think about it because I think it could be a real improvement in analytical clarity as to what we're talking about in that.
Just some predictive value.
Well,
Yeah.
but isn't that sort of, I would worry that would be like, sort of, we don't know that until the bad situation arose, right? I mean, the lawsuit that one would imagine happens, that's going to be the allegation inevitably is, you put a hole in my suit and as a dry cleaner, but you were also my lawyer and I had to show up in court and I looked like a bum. And the point is, of course, that's how, so I think that it would be bad to have kind of an ends, looking backwards definition.
Right, a hindsight bias definition.
Yeah.
Yeah, I hear you. Now, it's got to be, it seems to be, it has to be.
I mean, I guess it could be a reasonably foreseeable impact on your legal rights.
Prospective kind of thing, right?
And the
It's
closest,
basically a duty issue.
the closest,
It's really a duty issue.
the closest the authorities get, I think, to your point, Marshall. I mean, they do have in Common 8, which Steve has in there, they have this concept of how do you figure out what are law-related services that are potentially subject to the rules. They'd say those that might reasonably be performed in connection with legal services and in substance are related to the provision of legal service. That doesn't go quite as far as what you said, which is looking at could what you do
in a law-related service context, impair or affect the legal rights of the client that's using those law-related services. But that's the closest standard I see in anything, is that kind
Yeah.
of discussion in the comment to the ADA
Just
rule.
intellectually, what Amy brought up, I think, is basically what we learned in law school. When you're looking for liability, the first thing you look for is there a duty? And do you have a duty to protect your client from possible adverse consequences of these other businesses? And that can say, well, are these other businesses reasonably foreseeable? Could they have an impact on the legal representation you're
Well,
undertaking?
part of this, it comes back to this piece that I now think we should be clear about, which is this opinion is about when is the business itself subject to regulation, and under what terms is the business itself subject to regulation. It's not, and I think we should be clear about this, it's not, or maybe it is, but maybe we should clarify that it's a separate question, right? What your obligation is with respect, as the lawyer who is practicing law, right? What your obligation is in terms of supervision of that business, right? Or exercising due care with respect to referrals to that business and so forth and so on.
We typically try to stay away from the due care.
Well, I just to say that
No,
that is
I'm
what
agreeing.
I'm saying, yeah.
No, I think that may be a smart way to approach it. Go ahead.
I was just going to pick up on that and say I think that's a really helpful distinction. So the referral issue and the supervision issue is the conduct of the lawyer. And you can, I think it might help us analytically make some points without making others that we don't want to make, to just distinguish and say, the focus of this, at least try to make the focus, at least part of the focus, and whether the entity is going to be regulated as a whole.
Right. I think that is what we want to do. And I think I haven't made this as clear as but that's basically the way I'm trying to run the back end of the opinion, right? When we talk about things like conflict of interest, when we talk about lawyer-client business transactions and so forth, I'm largely assuming that the business has done what it needs to do to be a non-law entity, right? And that the issues then are issues for the lawyer in dealing with a non-law entity. And I think that referral and scope of duty issues, right, could lead in that section, right? You could say, before you do conflict of interest, before you do referral, solicitation, so forth, you could have a section that says, look, one thing that's clearly true is you haven't given up your obligations of competence, including the duty to supervise, right, in these kinds of situations, if you're actually engaging as part of the representation with this business.
But do you mean what? I guess I got scared there. So if your role is, hey, client, I think you need, I don't know, whatever it is, law-related services. You don't have any interest, ownership, role with the law-related services business. Here's 3 that you could go.
Right.
Do you have a continuing duty to supervise that law-related service? To make
If it's
sure-
part of you, if it's part of the representation.
So that spills over into.
I mean, you say you could recommend 3 different, e-discovery providers.
Or litigation funders.
Right. I mean, but if you're going to interact, right, with them, if your representation of the client involves a sort of interaction with working with that e-discovery person, right, I think our understanding would be you do have some duty to make sure that how they conduct their business is consistent with the ethical obligations.
I just think it's interesting because you're absolutely right. that this totally gets close to the opinion we're writing on litigation funding, because.
I absolutely think we have to go line by line. And you and I, at some point, have to go line by line and see whether these things,
Right,
these
but
things
I-
actually intersect.
So I think that what you're saying, at least the implication is, so say your client goes and gets a funder, and then the funder screws up and releases in a way of some privilege. Is the lawyer, I mean, I know we're not, our purpose is not to give guidance on malpractice, but are we saying that there are lawyer ethical duties that may have been breached because the lawyer failed to supervise?
You know, I very much want not to try and answer the question. I want much more to point to the existence of the question, right? That could be that there are issues of that kind. I'm very uncomfortable trying to do, I think Marshall's conceptual points is there are other places to be in terms of, you can't weigh, you can limit the scope, right? But certain limitations of scope that require you to be an ostrich, right, aren't going to work, right? And other limitations that involve, sort of prima facie involve negligence on it. Anyway, I don't even think we need to get into all that in detail, but the framework would be more to say, look, if you're dealing with even if you're dealing with a separate business that is not a law business, right, there can be issues of that kind, and not to go much further than that. Joe?
Steve used an analogy a few minutes ago about slicing salami. I'm not sure I actually get the analogy, but I think what I take from that is, to the extent that we're moving into somewhat new territory here by suggesting disclaimers as supported by Rule 5.7, which are not yet a part of our law, and yet which I think are in fact part of the reality of the way law firms do things. Maybe this isn't the opinion to try to deep dive on all the little minutiae that we've been just discussing for right now.
It isn't the opinion to do that.
So
that was my initial instinct. I'm happy to take guidance on that score from the committee. I do not have a commitment to the discussion, the more general discussion about things like referrals and client business transactions.
Well, I think I agree with your gut feeling on this subject. Andrew pointed out that there's sort of a dichotomy between the front end where there's all these thou shalt not sort of things going on, and then the discussion of disclaimers. I think transitioning from that to the point of view that the argument that Steve has propounded here is probably far enough. If we go too much farther, we create an impossible task for ourselves, more specifically for Steve. There can be another opinion down the road that gets into this. I like the idea that we're saying, here's a problem, here's a solution that other people throughout the country are doing, which we think actually is reflective of what, as a practical matter, people are doing. Maybe we should think of this. Now, sometimes as a committee, we kind of back away from the lawmaking or proposing a new path kind of thing because that's not really our job. But I like this approach. I think it's valuable. I think it's something that we should pursue. I just think that we should do it in a manner limited so as to most lead to the success of that effort.
Well, I thought that the comment, and now I forget who made it, but the notion that, we make clear that this is about looking at when the rules would apply to the entity, and we somehow acknowledge but don't try to resolve the fact that, the lawyer's got obligations and duties and so forth that, are going to go beyond the analysis of the opinion. We focus, on how the rules apply and when to the entity itself. I mean, I agree. I think if we go much further beyond that, we're probably, doing more harm than good, quite frankly.
I personally am fine with focusing on the entity and using that focus as a device to not go into some of this other stuff.
That said, I'm not convinced yet. And I have to think, and I started this, and I have to say, Steve, I mean, I really like what you did with the structure. was not a criticism at all. And I don't have the perfect answer. I'm sort of the same place you were, which is like, I'm not sure how to deal with that issue. But I'm not convinced yet that some of that back end stuff has to go away. I mean, a couple of those things are very practical things that I think people want to know about. So, you know, if there is this other entity, you know, can that entity be telling people that come to it and came to it first that maybe they should go to talk to you as a lawyer? I mean, there's, some of those things are kind of nuts and bolts, and I'm not convinced yet we should get rid of
Some
them.
of them, well, some of them, let's be clear, the original opinion here, which was done by Mark Tuft and somebody else, I can't remember who else, maybe they did it together back in '95, and it's terrific, and it actually covers a lot of this stuff pretty well. There's some stuff in it that I don't agree with, but you could perfectly well. The profession can move forward perfectly well with respect to a lot of these back-end issues based on that. I also think that that some of the stuff I've done here, some of the fine points, like for example, what if the client finds their way independently to the business? So that probably isn't like a major issue. I think I wrote it up because, you know,
on that,
but I take it out in a sec.
on that point, just since I'm thinking that, and again, I don't, you know, maybe we will or won't keep the back end stuff, but the one that's I think actually isn't there that's more likely is what if the lawyer directs the existing client to the separate entity?
Well, that's in there in terms of conflict of interest. It's not in there.
Yeah, I meant in the solicitation or whatever, one of
Right.
the back end issues.
Right, but anyway, but that, I'm open to completely, I think the committee should decide what they think is most helpful. I personally think the stuff at the front is by far the more important part, because I think that it answers the question that the Rules Revision Commission punted to us, essentially, which is how to figure out how to do something like 5.7 consistent with existing California law.
I agree with that, and I actually like the structure you put on the front end. It's sort of, here's what we have, and then it gets to, but there's this unanswered question about, you know, possible disclaimers, and you have the ADA rule, et cetera. I mean, I like the setup of that in terms of the structure. Again, my original point was just that, and I'm not sure yet how to deal with it, but in discussing what's there already, some of it sounds so definitive at the front of the reader, where at the end, on the back end, we're kind of coming around to saying the moral here is it might not be quite as definitive as it sounds.
Yes, as being a first-year member, I'm sure this is water under the bridge for most of you, but it occurs to me there are two places where lawyers have obligations that are not directly related to the practice of law. And one is 6106, which is moral turpitude. That normally says this applies whether or not it's in practice of law. The other one is 6068A, which is basically respect all laws. And that places you with an obligation that if this ancillary business is regulated as something, and dry cleaner would be regulated, if it's regulated as something, you have to observe those laws. Beyond that, I think the only duty of an attorney that would bring it within rules of professional conduct might be to identify a situation where a customer of the business has expectations or there's legal services being involved, in which case you may have to identify that as a conflict and go through the conflict drill. I think with those three things in place, the observation of the law, if you're going to do an business, the observation of course 6106, that you don't make a misrepresentation, and having an obligation, which we already have, to identify a time when a lawyer-client relationship may be in the offing or may be presented, then you have to make a decision about the conflicts and go through a conflicts kind of analysis. That might be a simple a simpler way of approaching that. That being the case, noting the 5.7 and the disclaimer and the other thing, that's also valuable stuff for back reading. But in terms of an approach, it might be an easier approach than trying to invent a disclaimer where we don't have one
Well,
yet.
let me say, I think they're definitely not water under the bridge, but they are things that have been considered. So let me tell you how I thought about it. 6106, absolutely right, and it's the first thing we say on the substance is that you can't get out from under 6106 no matter what kind of business you're in. Right? I think your point about 6068A is terrific, right? And I had not thought about it, and we should make that point with respect to the conduct of the ancillary business, right? I think that's definitely should go in. So I'm in complete sync with you on those two. In terms of the treating this kind of like a conflict situation, I think your insight is absolutely dead on. And the problem is that there's a ton of case law and opinions that we need to deal with. I think what I've tried to make the argument for, and this is, I think, a contribution to the opinion, is to make the argument for that the argument for regulating a business that is not the practice of law as if it's the practice of law, right, depends centrally, right, on the client's customers' mistaken perception that it is the practice of law. So it's exactly analogous to the conflict cases, right? And or the what I would call the sort of implied attorney-client relationship cases, right? And then I would just say that the disclaimer idea is fundamentally your idea. That's exactly what the disclaimer idea is. It's essentially the notion that when a client, when a customer could reasonably misunderstand that the nature of the services they're getting, it's the lawyer's job to clarify in that situation if they want to be treated as a dry cleaner, not a dry cleaner. If you want to be treated as a professional fiduciary instead of as a lawyer, right, then make clear that you're not acting as a lawyer. Don't act as a lawyer, right? And then you're subject. Then you can follow the very detailed rules that apply to professional fiduciaries, some of which are different from the rules applied. Does that make sense?
Yes, it does. Thanks, Steve.
So, I don't know if this is helpful, but just to my earlier comment, I'll just give you just an example. So, in the background section at the beginning, I'm looking at the red line at 85, and we have this sentence. For example, what we said, this principle may apply even if non-legal services are provided through a separate entity devoted primarily to the provision of such services. So we're saying even where there's a separate entity. For example, where establishes a separate entity through which he primarily intends to provide investment advice, non-legal service, is nevertheless subject to the rules of professional conduct if she in fact provides legal advice in connection with her services as an investment advisor. I guess she is, but is the entity necessarily for the non-legal entity? I'm just not sure. There are just a couple places where it seems we're sort of saying,
Right.
and then later on, we're kind of suggesting there may be situations where, even in that scenario, if there was sufficient distinctness, sophistication of the client, et cetera, as to the application.
No, I don't think so. I think if you provide legal advice, right, that's what that opinion,
Right.
that State Bar opinion says is, if you provide legal advice, I don't care whether it's a separate entity or not, if you provide legal advice, you practice law.
Wait, but that's not the question, right? The question is, you provide legal advice on a matter.
Yeah.
Then you provide non-legal services on the same matter. Are you saying it's clear that you're stuck legally?
I think, well, the way, I have to go back and look at that opinion, but that opinion is saying if in your separate entity, Bundy investment advice, right? I'm an investment advisor. At least the lawyer in that case said, oh, and by the way, I'm going to provide some legal advice sometimes in that entity. I'm going to provide legal advice in the course of providing investment advice, whenever I think it's helpful. I'm going to step out of my role as investment advisor and provide legal advice. Court said, sorry, that's the practice of law. You're backing it. You're in the system.
But that, to me, that's where the rubber meets the road and is the hardest part. If the advice is coming from the lawyer who's operating out of an investment advisor context and entity, and he or she happens to provide legal advice as well, then of course, I think it makes sense to say not only are the legal services, but potentially everything a lawyer's doing in that universe is subject to the rules. But that's not quite the same question, I think, is what Amy was saying, and I was sort of questioning, which is, what if I provide legal services to a client? And again, it gets to this, the e-discovery thing, and at the very beginning, on line 53, we say, many non-legal services can be performed as part of practice law. For example, a law firm may often provide e-discovery services as part of its practice. To the extent the non-legal services are part of the practice of law, there are regulations outside the scope of the opinion. What I'm struggling with is this notion of, could you have legal services not through the ancillary business, but through your law firm or your legal practice? And obviously those services and that advice is regulated by the rules, but nonetheless have an interest in have an existing client, perhaps for the same matter, and you need discovery services in your matter. And you say, look, there's a whole bunch of people out there. I happen to have an investment in one of the different services. You're welcome to use any service you want. I'm making disclosures to you about my financial interests, all that kind of thing. Can they potentially go to that separate entity? And if that separate entity is not providing any legal services, they're truly like on your back end. It's assumed that they're distinct and everything else. Are the services provided through that entity, through separate staff, through separate corporate entity in a different location, through accounts that are not commingled with the law firm, are they automatically
No,
subject?
why would they be? I think they're obvious. They're not.
Automatically, wait, I need to get to the end of that question. They automatically.
Is their conduct automatically subject to the rules of professional conduct?
Don't you think that I would have hoped that this opinion would say, no, they're not.
That's what I thought, and so what I'm just saying is like somehow like that the fine point of the earlier decision, which people aren't necessarily going to get real clearly, is that the context of that was you didn't have the distinctness. You had the legal advice.
No, that's a case where there was distinctness, but the lawyer insisted on providing legal advice within his separate business.
Right. Well,
And I'm saying, so that's not, that case wouldn't have any bearing on the situation where there's a separate e-discovery company that is not practicing law. And we can't say what is practicing law, but it has to be the case that it's not practicing law, right, in order for this work to apply.
You're right, there was a distinctness between the two entities, but there was not a distinctness in practice between the legal service that was rendered and the law-related service, right? Because he actually, despite the distinctness, he ended up giving that legal advice in the context of the other entity.
I get the concern. I just think that description of that opinion doesn't really cut it because it isn't really talking about that issue.
Okay.
I think the critical issue that you're describing is, okay, can you provide legal services? Can you provide non-legal services through a separate entity in the same manner, right? and have those non-legal services not be subject to the rules of professional conduct.
With very good disclaimers.
With very good disclaimers. I think the answer to that, is, in principle, I don't think that should be unavailable, right? And I don't think I want, and maybe you tell me, I don't think we want to say exactly where that line is.
Oh, I agree with that. And
So-
I read the opinion as sort of that being the end of it.
That's the,
I'm just worried people on the front end aren't going to know the cases in detail. We're talking about some pretty
let me
fine
add
distinctions.
it with that in mind. What I hear you saying to me is the tone of the front end and the tone of the back end don't fit, right? The tone of the back end suggests that that would be what you described would be okay, right? The tone of the front end suggests it would be impossible, because in fact that's actually how the opinions read, because they don't ever consider this possibility. So it's really a kind of a point about making the analysis more consistent. I think part of this problem will go away, right, when I write a digest, right? Because not only will the digest make clear what's coming, right, but it will probably also discipline the way that the exposition goes in a way that modifies this concern. That's not a complete answer, because I think it's very much a question of probably turns of phrase in 5 or 10 different places, in my opinion. But I take the concern. If people are comfortable with the idea that we want to leave that possibility open, right? That's a question for the group, right? Do we want to leave open the possibility that a sophisticated client, right, with a sophisticated law firm can basically structure the relationship with the separate entity however they want, subject to not waiving negligence and a variety of other non-waivable duties of one kind or another. But they can basically say, yes, this is a non-legal business. We're going to run it according to the non-legal business standards, even though it's providing services in the very same matter where the lawyer is providing legal services.
Yeah.
Yeah, I just wanted, I think this is, I was having the exact same confusion that Drew's noting, so I just wanted to say this because
Yeah.
so for me, where this surfaced was on, when we start talking, so first we sort of lay out, I guess, where are we here? Background section, and we first sort of say, fiduciary services are always
Subject to
the
discipline.
practice of law, right? Or subject to discipline.
They're all subject to discipline. I'm a little bit
Yeah,
careful.
no,
I'm a little
you're
careful
appropriate
about
yourself.
that.
Yeah. No,
I'm
that's
trying to
fine.
find, there's a fudge there.
No, I think that's fine. But anyway, so we say that, and I sort of, and I'm trying to follow along and sort of schematically track this in my head, and I go, okay, I put that in the category of you're stuck with rules of professional conduct, and then we come down.
That's not stuck with rules of professional conduct. That's stuck with professional discipline. That's what I'm arguing.
Ah, okay. Interesting. Okay, I'm not sure I understand that. But
This-
anyway,
Could stop for a second. This
Yeah.
is a really important point that you all should understand. There is a line of argument that would say that if a lawyer is acting as a fiduciary, right, they have a non-disclaimable duty to comply with all the rules of professional conduct. Right? There's a way to read the case law, including the disciplinary case law, as endorsing that view. Now, I just think that's a mistake, right? I think that would be a mistake. There's no case that, where the holding is so ironclad that you can say we're doing something here that's wrong by suggesting that even in the fiduciary situation, a lawyer could do that. It's clearly wrong. But we're going to have pushback. People are going to say, isn't that right? I think the answer, anyway, So that's a big thing for me here. That's a big accomplishment of the opinion. I went out and talked with, in part, with Mark and Bob Kerr, because I wanted to understand whether they really thought that was where the law was, where it had to be. Right? So the idea that if you wanted to have a fiduciary business as a professional fiduciary where you don't provide legal advice, the fact that you have a law license means that you have to comply with all the rules of professional conduct, even though there's a whole regulatory scheme for professional fiduciaries that's very clearly spelled out. That just seemed wrong to me. Right? So I went to them and I said, what about this disclaimer idea? Is it really ruled out in California? Is there case law that says it's genuinely non-disclaimable? Right? There's not. And in fact, at that point, it became clear there was a lot of law that would support the notion of a disclaimer. But that's where the biggest pushback is likely to come from. If anybody cares about that, they're going to say, "Gee, a lawyer fiduciary, even if they're not practicing law, has a non-disclaimable duty to comply with all of the rules of professional conduct." That's the pushback. So I'm just making that with. I'm sorry, that's a big interruption.
No, that's okay.
But I think it's helpful to understand that that's the kind of lurking undersea creature here in this opinion.
No, I think that's, I not only think that's, I understand that, and I think it's a great intervention. And I think this opinion
Right.
isn't.
So anyway,
all
so
that
you,
much more.
I interrupted you. You were explaining how where my opinion was confused.
Well, it felt to me like I'm reading along, and I think, again, this is kind of what Drew's point was more about the sort of the change, the shift in tone. So I'm reading along and I'm thinking, okay, if you're providing fiduciary services, you're subject to the rules. And then I get down to sort of the paragraph on the bottom of page 5, lines 172, 184, and we start saying basically, if you disclaim, you might not be. And I think I just bumped up against the very sort of tone shift that Drew was pointing out. So I'm just echoing that. And I'm sure that that'll get ironed out when we go back and look at this.
Both those sets of comments are very helpful because I
mean, maybe we just need to foreshadow it a little bit when you're laying out.
I think that's exactly right.
Okay.
Because I like the structure you have, say, sort of up front, here's what we have, and then
Right.
you move on, so I like that, that's a good way to say it, I didn't use that, but I mean, and I'm not sure exactly how to do it, but something
Use some
that gives a sense early on that this isn't the end of the story here, kind of.
Right.
Because what we start with does sound pretty definitive in certain contexts.
I think that I agree with all that, and that I think that gives me enough to work with, just so I can, because I think the next step is to try to write a digest, among other things, and that will help also to think about what more should be done early in the opinion to help the argument track better around what's in the digest.
That, we can move on to another opinion, but before we do, just I want to just give you one quick general comment. And then also, I think, Steve, you raised a good point, which is just if there's any input from anybody else on the committee about this sort of issue, about at the end of the day, how do we feel about something that ends up saying it might be possible to disclaim it's the same matter. I don't want to leave here. I want to at least get some sense from people, the group's answer to the question. But before I do that, just one quick comment. I noticed that, so on page 4, at line 26, you're talking about the rationale for our opinion. And we say, we believe the rationale which best explains our opinions.
You're in the red line?
Yeah, I'm sorry. This is all in the red line. So it's page 4, line 126. It says, we believe the rationale which best explains our prior opinions is that the non-legal services potentially subject to the rules of professional conduct are those, and this starts to sound like, I don't know if it's standard, but it's kind of, the rationale is a little bit of gives us some meat on the bones here. Those whose relationship or resemblance to the practice of law is such as to give a reasonable risk that the client may mistakenly assume that the protections of the rules of professional conduct apply to those services. And then on page 5, we go on in the next paragraph and we cite the model rule approach. This is line 40. Line 140 on page 5 says, under the model rules approach, and here, this is how they define law-related services potentially subject to the rules of professional conduct, are those, and then you quote the language, that might reasonably be performed in connection with the legal services and in substance are related to the provision of legal services. I just had a note to myself that these seem like they were maybe addressing the same concept and they're slightly different. I didn't know, are we, do we want to be different than the ADA standard? Is there, I just didn't, and we don't have to get into it today, but that just struck me and I thought.
It's a super good question. It's a super good question. I think analytically I haven't actually done that work. I just tossed that rules language in there. The other formulation is an effort to deal with the California case law, and there's an inconsistency that ought to be addressed and ironed out. I don't know what the right way to do it
Today's
is,
not the
but
right day.
that's
I've
no.
thrown that out.
What are the
No,
lines?
it's a really
What
good
are the lines
point.
of the second quote, please?
The second quote's on page 5 at, starting at 140. So it's comment 8
Right.
that's being quoted.
It's a very good point, and I think it ties in. It actually ties into the tone issues in a way too. So it's very helpful.
So before we leave the opinion then, does anybody want to weigh in on the question that Steve posited earlier? Again, sort of having talked about this at some length now, the notion is that at least the intention as it was presently drafted is that there is the possibility, the answer to the question, could you be a lawyer providing legal services and potentially have a separate, distinct law-related services entity and have a client that you are providing legal services to through your law firm use the law-related services of the other entity and that entity not potentially be subject to the rules with respect to the services that it's rendering, the non-legal services it's rendering. You know, again, we're not saying definitively, the notion is it might be possible if you have a certain type of client and sophistication and disclaimers and so forth. And so I just want to get some sense of what people outside of the subcommittee think about that concept, because that is the way it's sort of presently framed. Okay, Joel.
Like I said earlier, I support that idea. I think it's the logical place where,
From my experience, it's also, I mean, practically, that's what people are doing. Other people were talking about the product. I mean, and that this is the scenario that people are struggling with. What they want to do is firms that, you know, it's not the back room you discovering this. They want to have a separate entity and they want to provide legal services and potentially have clients using that separate entity. And so
there are lots of examples. I'm sure every one of us could come up with examples anecdotally of which we're aware of which people are doing essentially this already. And
oh, there's no question. People are doing this already.
and
We're trying to figure out if they can.
Well, I'm so pleased because for months I kept saying, tell me about what, and now that I've analyzed it, I've figured out what people are doing by figuring out what the holes in the law is, right? Okay. All right, can I ask one other question? I think everyone should think about this fiduciary piece, and if anyone wants to read some of the cases, which are not very enlightening, to see exactly what we're doing, I'm happy to read the cases that are shown. Second thing I would say is, I think, in addition to this question of whether we need all the apparatus in the back about conflict of interest and referrals, is whether this would read better as a white paper than as an opinion. In part, whatever, there's an alt, it just strikes me that there's a certain sense that it might, in part because we're doing so much work with the law, it might be better to be a little more direct about some of the difficulties and explain why, in a way that might not read it. I don't know, I'm just asking. I put it out there.
I wonder if staff could give us just like some.
What are the sort
What's the
of, how do
difference?
people think about whether to make it a, whatever, information paper, or, I don't know what exact term.
So if it's not an opinion, it's colloquially an article. But you could describe it as something other. We could do some research as to what that might be. Typically,
I thought when Drew was doing all that work, when Drew was doing all that work on.
well, we've written what we call ethics alerts, which is usually a topical issue. The crisis with home loan modification legal services. So this committee, OCTC, is getting inundated with complaints about lawyers teaming up with non-lawyers and clients being harmed because their houses are going underwater due to the financial crisis. This committee acts quickly, doesn't draft an opinion, but drafts what they call an ethics alert, gets it out there, and highlights and discusses, in some cases analyze ethical rules and pitfalls that lawyers should be aware of concerning this practice, which is taking place right now. Changes with the SEC,
The ones we've done.
SOX, and how that conflicted, Sarbanes-Oxley, thank you, how that conflicted with the lawyers who do confidentiality here in California, that operated better as an ethics alert. So it's called an ethics alert.
That doesn't sound like the right.
That's a title we refer, but again, you could rename it. It could be an article. It could be.
But
Ethics hotline.
when Drew was doing, what was your project on, Drew? I can't remember.
Ethics hotline.
I think it might have been at one point back on the law, changing between law firms.
Uh-huh.
Right.
And it's
was
related to
Right.
changing between law
Right.
firms, and question of are we breaking any new ground? But then again, wouldn't it be helpful and instructive? And if we didn't do it as an opinion, couldn't we do it as some? I thought there was yet another term.
It's called a hotline article, like we did one for Wendy Patrick's article about what our friends for. It's not necessarily an alert, it's not,
Okay.
and there's been a couple of, like
Yeah.
ethics primer.
Maybe a
Primer.
Could be a
I think
primer.
that was it. Is that the same?
I mean,
We can call it.
let me cut to the chase. These are all different titles,
Yeah.
but in publication form, they're essentially the same thing. But sure, now that because I agree, maybe a primer is a better title because you thoroughly flesh out, like the ethics primer on limited scope representation, something I refer to a lot. I think it's a great place to start, and it highlights all these issues that lawyers should consider before they engage in limited scope representation. It might be similar here, something for lawyers to consider if they're going to refer their clients to a business that's owned by the law firm, what to consider. So you're not stuck on any title, but those would be the
Well,
three.
we can decide what we
could I-
like, and then we can decide how to title it.
And then the second part about that is you have more, you have more leeway in those alternate forms of publication than in ethics opinion. Ethics opinion is, as we all know, generally more formal. You're tied to existing law, rules, and authority. And so that also weighs in on determining which approach the committee wishes to take.
Could I rephrase the question to staff? Is there something about this opinion right now which says to staff, ooh, this is going too far or crossing some line, which means it should be something other than an opinion?
For me, I don't think I'm there yet. This was a great conversation. I think it's certainly worthwhile to develop it as opinion at this stage, but keep an open mind. Maybe when you start tackling these knottier or more difficult issues.
I mean, not bearing.
Not bearing, exactly. These more difficult issues, it may be better to publish it as an alternate.
I hate to cast myself as the activist, and I'm thankful that Matt Hodell's not here to hear me say this, but you know, it seems to me that in some respects, we're actually playing catch-up to what actually is. I don't see us breaking new ground as much as saying, yeah, you guys seem to have figured it out pretty well. You seem to have identified the issues, and this is where we think they are. I don't see that to be beyond our function or beyond the function of an opinion.
Sure.
Is there and I should know this after a couple of years, but I don't honestly know whether there's a line that gets crossed or not when we do that.
No, I don't disagree with what you're saying. I would just caution there's no hard and fast rule. I think it's just the responsibility as a committee we should all be sensitive to when drafting an opinion, and that is we're not a judge or a jury as much as we want to be. You know, so we absolutely can make legal conclusions, and we do in all our opinions. But you know, my advice would be that should be tied to existing law and authority. And you know, it could be described or cautioned as there is no law on this issue. But as a practice pointer, these are the steps or considerations an attorney might take. So there are certainly drafting skills and techniques that can be implemented. But I would just say envision all the ethics opinions that you've consulted and read over the years and try to consider whether these issues can be analyzed and concluded upon in a similar format. And if the answer is no, or we're somewhat uncomfortable, or it's an issue that truthfully needs to be litigated, you know, two sides, and to be out there arguing before a neutral fact finder or arbiter, then you know, discretion's a better part of valor, and maybe we shouldn't go out that far and reach a conclusion. I know those are different things I'm saying in terms of answering your question. I think those are the things I would recommend the group think about when trying to chart a new course, and there's less authority to rely upon.
Since this is my first year, I'll ask a basic question. Most of the opinions I've read, I think uniformly had a factual scenario, and then questions and then a discussion and answer. Right now, you're doing it somewhat in a broad brush, analytical fashion of what different courts have done, other state bar activities have done, ABA. So right now, it's not in this normal structure of an opinion. So if it goes to an opinion, would it be your thought that you would come up with 3 or 4 good scenarios to kind of pinpoint the borders of what we know and what we don't know? Because you could do that if at some point there are areas.
I think that's a really good idea, and it's actually consistent in some way with the comments that Amy and Drew were making there as well, which is now that the opinion has more or less figured out what the law is, right? In the sense of, and found some things in the law that the law doesn't, in fact, know are there. Lawyers do, but the law doesn't. There might be an opportunity to set things up, right, in a way that helps helps with the flow issues you guys are describing, and also helps with the sense that it reads a little bit like a white paper instead of like an effort to deal with specific kinds of questions. And so one of the questions might actually be, can you ever do this in the same manner?
And you could even have a distinction where you have the separateness, but the lawyer actually renders legal services in
Yeah.
law-related entity.
Well, we'll talk. I mean, I think that exactly what those hypotheticals should consist of is not completely clear in my mind, but I think it's a really good suggestion. And which one?
I stepped on your hand, sorry.
Okay, I'm famous for doing that.
Well, I think just to comment on what type of writing this should be, I think an opinion is a good idea. There's been a lot of development in this area of what people do. And so even though there's a wonderful older opinion which deals with the general framework, I think an update opinion which addresses the new types of businesses that are going on these days will be helpful and give good guidance to lawyers. And I know some, personally know some lawyers who are doing these sorts of things. I mean, I know one guy who has got who does corporate startup type of legal advice from his law firm, and he has a related entity which is a kind of incubator for startups, which then connects the startups with VCs, itself provides some VC funding, and then and it's not, they're not really arms of each other, they're completely separate entities, but the entity will sometimes refer its clients to the law firm for contracts and drafting and other legal services. But the founder of the law firm is also the managing director of the entity. So here you have a very, tightly knit situation, which is specifically directed at a type of business situation, specific type of corporate law, which is maybe more prevalent than when the article, the opinion came out in the 90s. So I think it's a good idea to have this as an opinion, which, as we've been discussing, touches on the edges of what we know, and gives some caution for what happens in those fuzzy gray areas as well.
I agree. I think with the developments in technology too, more lawyers are stepping out from the legal advice they give in their practice and other businesses that they're trying to start up. So I think it's a good idea to have it as an opinion that builds on the original.
I mean, I think we can see where it goes. We don't have to just cite it today, but I mean, I sort of share the view. I'm less concerned about we're legislating or making a new law because of the point that several people are making, which is we're not really going out on a limb to say start doing things that nobody's doing. I think Joel said, I mean, it really is catch up. All this stuff is going on, and so in that respect, I feel a little more comfortable, even if the law hasn't affirmatively said, gone as far as you can do X, Y, and Z, looking at what's happening, what other authority says, and having a reasoned, principled basis to say, in this context, we'll at least go this far, and so you may be able to do this, or whatever we're going to end up saying. But that troubles me less than some of the situations where we've had opinions and sort of wondered, well, are we just, legislating here, going out on a limb?
Right, they're already doing it, and they need the guidance, so.
So I agree, and I think the opinion is structured in a way to work as an opinion. We're stating what the law is, we make it clear what the law is, and then we say, based on what the law is today, here are some things lawyers should think about in terms of how to conduct themselves in order to comply with their ethical obligations when they engage in this behavior or these activities. And that is not inappropriate for an ethics opinion. What may be inappropriate is like, well, here's an exception to a statute that we're just going to write. That's not. So I'm just giving an example of the absurd. But I don't think this situation, these facts, and these questions present the problem of one I was describing. I didn't mean to say that this opinion does. I was trying to give an example of where it might be better not to not to do an opinion.
That was all very helpful. I think I have.
We gave you your full.
Before we get out, I do have one more question for Steve. I know we spent a lot of time on this opinion, and I hope it's just a quick question, but it's specifically with the concern about the fiduciary law, the cases. I agree with how you described the cases. That's how I understand them. And I just want to make sure I understand what your question is that you're asking the committee, and I'll take some time to look at this myself. And that is,
I think
whether the lawyer can disclaim the obligation to comply with the rules of professional conduct when they're acting as a fiduciary, but not an attorney.
But not as a lawyer.
Because I think the case law states, none of those examples, as I understand those cases, touched upon the ability to disclaim. The lawyer did not disclaim. They just engaged in that behavior. Correct me if I'm wrong. And the court says, well, if you're going to do that, the rules of professional conduct are going to attach, and they will apply.
That's why what I think the best reading of the law is, right, is that a lawyer who engages in any fiduciary activity, including acting as somebody's agent for the sale of their car, something like that.
Yes.
A lawyer who engages in fiduciary activity, right, without a disclaimer, is subject to the rules of professional conduct. That's the way I read the case. That's the way I read it.
And you don't disagree with that legal
I do
conclusion?
not.
Right.
I do
Okay.
not. I think
That's
what,
how I
I
understand it as well.
I think what we're fighting off is, you're absolutely correct, that there are no cases where the lawyer has tried to disclaim.
Right.
So I'm just trying to say the case law does not rule out disclaimer, and disclaimer
I
makes
agree.
a lot of sense for other reasons, even in the fiduciary context.
So I have one more question, that is, there are other cases, and maybe some of these, and correct me if I'm wrong, or if you're aware of them, that also when a lawyer holds himself out as an attorney, whether or not they're acting in a fiduciary capacity or not, there's authority that says the rules of professional conduct may apply to their conduct as well.
Oh, I assume that. I think that's absolutely correct. I'm not sure that's within the scope of this opinion.
But I just want, and I don't conclude one with the other, I'm just curious, within the opinion, you're acting as a lawyer, a law firm, you know a client, I mean, the person you're going to be referring to the other business only knows you as a lawyer, so might that predicate already be triggered based on the pre-existing relationship between the lawyer and the client before you refer them to another business? The client only knows you as a lawyer. But I guess,
But you're disclaiming.
right, so,
Fixing
But the business is disclaiming.
agreed. So I only bring it up to say, might we also wish to reference, and I'll see if I can find that authority, and maybe I'm mistaken, it's just something I think I've heard or read
I
somewhere.
think this really comes up, the issue you're describing is really implicated. It's very much involved in the referral issues.
Yes.
Right, and the lawyer-client business issues. Because you could have something that's a complete separate entity, right? And the lawyer can still trigger 3300 by referring to that separate entity, because the referral itself, right, can be viewed as a form of undue influence.
Well, and also, this is going to speak my ignorance, but lawyers act as realtors all the time. I think a realtor is acting in a fiduciary capacity.
Absolutely.
Okay. So I think in those examples there are lawyers that act as lawyers and real estate agents, and they could say, and then say, Andrew Topp, realtor and attorney at law, and you come to me and you're like, I want to buy a house or sell my house. I don't see why I can't say I'm only acting as a real estate agent. Although I'm a lawyer, I'm not providing any legal services to you. If you need legal advice, go consult an attorney.
I completely agree with
So I think that's
That's
an example.
There are.
And I think that happens all the time.
There are a bunch of cases where lawyers have gotten in trouble under the ethics rules for actions taken in their capacity as a real estate agent,
Exactly.
as they were providing legal services
Yes.
in the same transaction, and they hadn't made.
If you're silent upon it, then
Right,
heck
exactly.
yes, the rules are going to apply to
No,
you.
but
Yeah.
I think absolutely the thrust
Because
of
you're holding yourself out as.
the thrust of this opinion is to say that you can alternate between hats,
Yes.
right, in different transactions.
Yes.
Provided you're clear that when you're wearing your realtor hat,
Right.
that's all you're doing.
And I think this opinion would both be public protective as well as lawyer guidance worthy if we're clear about that. It would serve everybody. You can do both.
That's-
Just make it clear what you're doing. There's no confusion. Document the heck out of it, and we're good to go.
That's essential. I think I'd like to make that the introduction.
Okay, enough
Clear
time.
what's going on.
Thanks.
Absolutely.
Great.
That was an incredibly generous discussion and helpful. I appreciate the time that you put into it.
work on anything. Okay, Andrew, when do we break for?
I think it's your discretion. I see some food out there, but we could go for 45 more minutes, or you could break now, or it's your discretion.
Eric, I know you have some time. Do you want to do it now?
I'm happy to start, but I don't want to impede anyone's enjoyment of lunch either, so.
Yeah, that's fine.
Might as well get started.
That's 13 minutes now.
Why don't we do this? Why don't we start litigation funding? She's got to go at noon. We'll see how far we get.
Sorry.
No,
Just
I don't
go
know,
to a call.
Just for a call.
But we'll spend a little bit of time on that before lunch. Then this afternoon, we'll make sure to get yours done. I know you have a timing issue, and Richard, you're going to get to your opinion as well. And so why don't we let's spend a little bit of time on litigation funding.
So it starts on page 41.
Thank you.
And so there's the subcommittee. This is 14002. Steve, Eric, and the subcommittee and the advisor. Amy's the lead on this agenda.
Okay. So, what did you say, Andrew?
The red line's on 49.
Okay.
The opinion's on 41.
Yeah. All right. So what did I do since we last talked about this opinion? What I remember principally is that Steve made the suggestion that I go back and look at the ABA white paper on litigation funding, particularly with respect to the independent judgment issue, which I did, sort of put more in about that white paper and the concluding it reaches, which is essentially, as I understand it, there could be a scenario in which the litigation funder exercises sufficient control over the litigation that it would be unethical for a lawyer to represent the client under those circumstances, and then I contrast that with a New York City Bar Association opinion, which is a little odd in the way it phrases it, but I think what it's trying to say is if the client consents, you can, it's okay for the litigation funder to have the control, whatever degree of control, which seems, which the way I came out is that seems more consistent with California's general approach, which is a sort of consent-based approach, and that it seems odd to me to suggest that there are some times when the client independently enters into a contract with the funder that has certain implications, and then the lawyer can't represent the client because the client has agreed to certain conditions with the funder. So that's where I came out, is that if everything's clear and the client has clearly agreed, it wouldn't be unethical for the lawyer to represent the client under those circumstances. I think that's the major sort of substantive change I made in this. I still think it's very thin on scenario one, which is the consumer litigation funding. I just simply have nothing addressing the kind of the issue which a lot of people are concerned about, which is oppression of a plaintiff who who's forced into a very one-sided litigation funding contract, and whether the lawyer has any ethical obligation to intervene and be kind of the nanny lawyer. I don't know what we as a committee think about that, so I just have ended up not touching it, and therefore I think sort of the scenario one, which is about the consumer funding situation, just doesn't say a whole lot. So I'm interested in any thoughts on that. I still am struggling with the notion of whether there's a difference between conflict of interest and impact on independent judgment. And I think the opinion reflects the fact that I'm not sure about that, or whether they should just be merged into one, especially because in California we don't actually have a standalone rule about exercising independent judgment. That's all I've got. I'm sorry it continues to sort of be a mess in the red line because I keep reading, working at like kind of dough, and it's, still kind of falling apart. And I appreciate it to the extent people will force themselves to struggle with reading the red line.
Okay. Go ahead and open it up to the subcommittee. Anybody on the subcommittee comments they want to make? I'll make a couple and then we can open up the rest. In the statement of facts, in the first paragraph, where it's discussing scenario 1, at the very end of that, we talk about the
Red line or
report.
Red
I'm
line.
looking at the red line. Sorry. I'm always looking at the red line.
Yeah.
The very last sentence says that, and again, this is setting up the facts in scenario 1, the funder pays the attorney $5,000 referral fee. Later on, and maybe I missed it, but should we be saying up front that it's not disclosed to the plaintiff? Because I think that's a fact that you put in later.
I just say, what I did later is I said, well, the facts don't say that they disclosed, and so if they didn't disclose. But anyway, we certainly could put that in.
Okay, and I may be reading wrong. I had thought later it basically, I thought somewhere it affirmatively said it was not disclosed, and I thought if that's the facts, we should put that fact up in the front. Not a huge thing. Another point over on page 2, again, the red line, this paragraph starts at 67. It says, other arrangements by an individual or entity other than the client, other arrangements by which an individual or entity other than the client shoulders the expense of legal fees, such as contingency fee arrangements and liability insurance, are well established in the United States. You mentioned 3-310F later, but I just put a question mark. Would it be worth mentioning that up front? I don't know. I mean, it's just another example.
Yeah.
And you posed this question in footnote 1 on that same page. This is the discussion about, Champerty and Barratry. And I think you end saying, should we move this into the text? Is this a, I don't know how others feel about that. I mean, to me, I think it should be in here to address it, but I'm probably okay with it in a footnote. I mean, it gets addressed in a lot of the opinions that deal with litigation funding. But I guess my reaction, I could go either way, but to me, it's kind of, it's saying there might be this legal issue out there. Additionally, you need to think about it, sort of telling you what California's, law has been on it. I guess my inclination would probably be leave it in the footnote, but that's just my 2 cents. Let's see. Over on page 69, this is under the independent judgment paragraph. I'm giving you the wrong page number because I got 2 page numbers on it. Over at line 104, I think is the heading that begins independent judgment disclosure of relationships. On line 112, it says if a lawyer actually has a relationship with the funder, and I just put a question mark here to myself. We want to say a past or existing, and how do we feel about that? And I don't remember specifically. I think the facts say that maybe the lawyers use this funder one other time. Does it? This kind of reads, I guess, if you take it literally, like, if you have an existing relationship with this funder, do you have to make the disclosure? But I would think if you had sort of a relationship over time, even if you weren't actively using them at the moment, we would probably be inclined to say that's something that should get disclosed. Oh,
You're
yeah.
talking about a relationship beyond the fact that you received a $5,000.
So this is a generic
Right.
sort of discussion, and so what this is about, I mean, I don't think that the referral fee would be a relationship. I mean, it's definitely a disclosure, absolutely, but not because it's a relationship. I think what I was thinking of with this discussion was things like prior scenarios in which the funder funded another client that the attorney represented.
I apologize, I haven't read this since last time I got behind, but do we define what a relationship is? Because if you have constant referrals, does that create a relationship?
Well, I think that's a question. I mean, I think it's, but I think we can have a greater discussion in the opinion about that, but I think, I certainly think my view would be that one prior contact is, I don't think I'd be prepared to say that's a relationship that has to be disclosed. I think a consistent pattern certainly would be, and maybe even one would be enough. So that would be my thought.
I had an expert once testify on this issue, and I asked him what his standard was. He said, what would you want to know
Right.
about your lawyer?
Yeah, yeah,
It's that simple.
right. Well, sort of.
I mean,
So it's,
it
once
doesn't
you're
hurt to
suing
say
your
it.
lawyer, you want to know everything. But I think that seems like a fair observation.
Well, so at some point, I mean, that could affect the facts too, depending on how we flush out on that question. I had that as another question mark too, like, if we wanted to, we could build factually more of an, if that helps to give them to, this is a person who's gone back to this person a bunch of times, or has a very solid sort of past relationship with them. On line 156, 157, this is just the sentence, by the way, I was keying off of. It says the lawyer did not disclose to the client that he received
You're
a
right.
referral fee. So,
Okay.
what else? Then, I guess my only other point at the moment, I mean, this kind of gets to your independent judgment question, but over at line 240, where we start with the independent judgment discussion, I just had a note to myself. I mean, is indirect influence going to be sufficient? I mean, we have facts here where, we've given the funder a certain amount of control over the litigation. But I'm wondering, I mean, how much control does it, is the possibility of an indirect influence sufficient to at least create some kind of disclosure of it? It seems to me it probably would. I mean, if you look at things like 3-310F, you're not saying the third party has any control whatsoever over the matter, but the mere fact that they're going to pay the fees creates the possibility, even indirectly, that the lawyer's judgment's going to be colored. And so I just wondered, somewhere in the discussion of independent judgment, if we have, and these facts go beyond sort of the most indirect form in which you could be influenced, which still exists, I think. I mean, it's something,
What do you mean by indirect influence?
Well, I guess what I'm thinking is, like, for example, under 3-310F,
Right.
those scenarios typically the third party's paying the fee, but there's still a concern that your judgment might be impaired. I'm considering that sort of more indirect. There's nothing that says the third party has a right to control anything in the litigation, whereas the facts here have gone beyond sort of just the possibility indirectly to be influenced by the other person's involvement and given them some specific things, control in certain scenarios. I don't know. I'm throwing it out as
It's kind of a slippery slope. I mean, I would like to return to the whole independent judgment conflict conundrum that you're struggling with, but I don't think we can do it before noon.
I can be a little late on that.
It is late.
Yeah, I know.
So, just a couple of quick things. One is, I wonder if in scenario 2, maybe I'm totally missing this because I wasn't there. But I wonder if in scenario 2, there isn't actually it doesn't quite say this, but isn't there a, isn't there a 3310F issue?
Well, there's never a 3310F issue, as I understand traditional litigation funding, because the money goes to the client pays.
Oh, okay, well I think that'd be
Maybe I need
worth
to say
spelling
that,
that
huh?
out, right? Because it
Yes.
says here, it says, under the terms of the deal, funder supplies a portion of the firm's fees.
Right, that's a great one.
You know, so one way or another, it seems to me we need to either put it into 3310F or take it out.
And we do mention three.
We do mention it,
Well,
but we don't
be-
discuss
be-
it.
Because I think I think it's very interesting that the rule, I think 3310F doesn't touch litigation funding directly, it isn't applicable, but I think the kind of penumbra of 3310F needs to be considered.
And it could be, that's a nice way to do it, if you actually say, well, the arrangement is it's going, so that it's going to the client, so it isn't technically a 3310F issue, but the same issues arise. That feels like potentially a neat way to do it. With respect to the referral fee, you mentioned 3310 in discussing the second hypothesis, the second arrangement. But maybe I just got this wrong, but I read that earlier opinion about the insurance case, the insurance referral fee, says the 3300 also applies. And so you need to, maybe I'm wrong, I could be misremembering that, but if so, I think we either got to figure out whether either put that in or I think that the reasoning of that, as I remember the insurance, the reasoning is something like, you know, you're exercising your independent the client is sitting there and you're purporting to exercise your independent judgment in referring them into a situation where you're getting a fee, and that is a client business transaction.
Okay, well, that's a
So
great
you want
point.
to take a look and see whether I got that right or not.
Yeah.
That's all I got.
Okay, anybody else?
I've got a few comments. You want to take it now or ready?
Yeah, no, I mean, I'd rather take it now, because otherwise.
Great. So I'm on the facts. I understand that funding can be either recourse or non-recourse in the real world. I mean, that actually recourse loans are being used, which is kind of astounding to me. Yeah, litigation funding. I read that in an article. I find it kind of hard to believe. I assumed that all would be non-recourse, but do we want to, if we want, I think we should put non-recourse in here to make it clear.
Yes, agreed.
There is on page, I was looking at the claim, so let me just get to the introduction on the line. When you're introducing, it's the paragraph starts on line 57. You're asking for cites. Let's see, no, that's not the one. It's on the next paragraph. Where's the paragraph? It was the one on where you're looking for cite authority for the independent judgment.
This paragraph that means that litigation funding of some types has existed. It's around.
I don't think so, because that.
No, I'm on the wrong one.
Yeah.
Sorry.
That is where I have that is where I say add sites. But that's just a note to me to add some more little articles complaining about how litigation funding is evil.
There's also some debate in the literature about mandatory disclosure. That's not a part of this opinion, but maybe it's worth a footnote. I know the Northern District was considering
I have a
it.
footnote on the Northern District rule.
Ah, I missed it, sorry.
That's okay. I mean, they didn't, they ultimately rejected that.
I didn't know the outcome. They did reject it?
Footnote 2.
When you talked about the conflict of interest on page, line 90, starting around 90, you say that such relationships, the conclusion is such relationships must be disclosed. And I'm wondering, well, what about the authority for that? I agree, I think, with the conclusion, but is that a substantial development kind of assumption? That this kind of deal is a substantial development in the case under the rule?
No, but I take your point, I'll add some authority there.
And also, there's nothing-
It's a 3-3-10.
Yeah, and also there's no reference to written consent. I think that's part of, to the extent there's a conflict of interest, there has to be
Not if it's a
written consent, no?
3-3-10B. Not if it's 3-3-10B. That's a disclosure only rule.
It's coming. That's gonna be, that's what the law will be when the new rules come into effect. And it's probably prudent for people to do it anyway.
Yeah,
Yeah.
that's kind of where,
Well, good point about adding authority, thank you.
All right, just a couple more. On the, I have to find a reference number here, I'm sorry. Your discussion, it's in footnote 3. There's a long footnote. You discuss the case law on the issue of the common interest issue. What page is that? For now on, I'm going to use the red line. Forgive me. What's your footnote 3? Did you take it out?
Yeah.
Footnote 4.
You're talking about 4.
Oh, it's 4. Yeah, now it's footnote 4. Sorry. I found a pretty good case which talks about the common interest concept in California. So we don't really have it by that title, but we have it through construing evidence code section 950, whatever. So it's Citizens for Series versus Superior Court. I can give that to you. I think that's a better authority than, I mean, it's worth citing because it's California as opposed to the federal site. So I would recommend that.
Is it a litigation funding case?
Sorry?
Is it a litigation funding case?
No.
Attorney-client.
It's a disclosure. It's a disclosure involving the developer in a project, this shared documents with the city planning staff.
Right, yeah, I know series, I know that case.
So that's the one. So it's on the common interest exception.
Okay,
But no, it's not a funding case.
okay, well, thanks.
Thank you. So that's it.
That's a good point to raise.
Anything else we can?
That's it. No, sorry.
All right, why don't we go ahead then, we'll break for lunch, let Amy go to her call.
What, we should announce the time that we'll resume.
Yeah, how about
1 or 1? It's up to you.
Let's do 1:15. Do 1:15.
All right, we'll break until 1:15.
Justin will call back in at 1:15, okay, we're disconnect for now.
Okay.
Whenever you're ready.
50%.
All right.
But we have 4 minutes.
Let's go ahead and get started here again. We're going to move to 140001, so we can talk about that before Eric has to leave. So, Eric, why don't you go ahead?
Sure. All right, so this particular draft has been percolating for a little while. After the last meeting and the very helpful comments that came at that time, the major substantive changes deal with developing the second scenario involving a larger law firm setting. That's an entirely separate scenario now. Oh, and I'm sorry, this is on page 31 is the red line. I have some comments I'll throw out there and some questions for the group collectively in terms of approach. I did get some very useful materials from Kendra and also from Stephen yesterday that I've only had a brief opportunity to review, but they deal primarily, at least Kendra's materials deal with age-related infirmities and addressing those in a very practical way. Not so much, although it definitely touches upon the ethical issues that are implicated, in particular the obligation to report. It's useful, I think, most from the perspective of some of the signs and symptoms to look for, and the same is true with regard to Stephen's materials that he provided yesterday as well. So I will incorporate those in the next draft along with whatever comments and observations may be offered today.
Okay. Well, maybe you want to get some comments first and then deal with your specific questions?
Okay, sure.
You want
So, I know our drafting committee has become somewhat truncated a bit, but Kendra is the new addition, and it's Drew and Suzanne.
Yeah, it's just if there's anybody additionally who want, I think we were even more anemic before, and Kendra volunteered to be on this one, but yeah, if there's anybody else who wants to be drafting it, let us know. Well, Kendra, do you want to?
I do have some comments and suggested revisions, but I think it might be more worthwhile for me to try to incorporate maybe through red line among our small group rather than go through each one here and take up time doing that.
Okay.
You know, for the most part, it's just kind of reorganizing things and taking away some of the repetitive stuff. But I know when we discussed this the last time, the big debate we were having was how much you have to reveal to the client when you bring that up. And it looks like that was revised a bit, and I think the opinion reflects the consensus that you only have to tell the client what is necessary for that representation, and that you don't have to go into more detail about the actual impairment, because that could bring up some privacy issues. But it still seems a little bit short on that as to what is a significant development that we're required to inform the client of, and then how much can be said, where we have to draw that line. It does make a note that you have to, that if the client wants more details, you direct them then to the impaired attorney and allow them to, you know, give those details if they so desire. But that's the only real hole that I see there that maybe we need to fill in, or, you know.
And apropos of that, and after looking at the materials you sent, it raised a question in my mind as to whether we want to include, as part of that determination, consideration of 2-400 and 8.4.1, and how that may tie in, because obviously in terms of the information you're disclosing and the extent of that information, there is a very real and practical concern that there could be discriminatory conduct as a result, whether inadvertent perhaps or intentional. So.
Right, and that all brings up another point with these new rules that we have all kind of heard may come out soon, or this year at least. You know, there are some changes to, for instance, the withdrawal rule that I don't know how we'd like to address that, whether we want to ignore it or address it in a footnote, at least here. I assume that we'll still be working on this if in fact those new rules do come out within this year.
Show a little faith, please.
Hey, maybe we'll speed on through.
We've had a couple of opinions like that where we thought, well, the rules may can't come out and modify something, and so what we've done, at least on 1 or 2 occasions, is kind of kept that in mind as we've worked on the drafts, maybe even put in something or worded something in a way that we think is going to help facilitate sort of the fine tuning that will have to occur, not if, but when the rules get approved.
Right. So there's, you know, the current rule is whether it's difficult or unreasonably difficult, and the new rule just is difficult. So that would essentially remove that paragraph, you know, or make it a lot less involved. And then, yeah, my other point was, you know, we kind of breezed through how a lawyer would know if one of their colleagues is impaired. And you just made the point, Eric, that maybe we want to put in there some signs and things that they can look out for, which I think are pretty well documented in a lot of other sources that we can cite as well. But my issue with this opinion is I deal with this in my practice. And the reality, applying these things in a realistic situation is a lot harder than it comes across on the paper. So I don't know if we want to get into some of that, some of the practical and realistic aspects of it, or if we want to just scrape the surface as we're kind of doing here. So I'd be interested in seeing what everyone's opinions are on that.
Yeah, and that last point is one that I had actually made a note in terms of wanting to discuss, because we offer guidance, perhaps masked a bit as advice, but there is an element of impracticality to a lot of it, and superficiality to it.
Right.
So, great.
I don't mean to pile on, but I think Peter raises a really valid point here. This whole thing as it currently exists seems a little ivory tower-ish, and it does not seem to adequately address the really nuts and bolts and grittiness of being in the role of a relatively junior associate and having to say, either in a big firm context or worse yet, in a little firm, I'm sorry, you're not doing your job right, and I need, you know, we don't essentially discuss the career suicide aspect of this, of fulfilling these ivory tower expectations. And I don't think we would be doing our constituent audience a full service if we didn't, at least in some way, acknowledge the difficulty of the situation.
Well, I think it might be useful to have a discussion about what some of those practicalities are, to get a sense of, you know, if we were to get more at that level, what kind of things we're talking about.
I want to emphasize, I don't think your conclusions are wrong.
Right.
But it's just, it's simple to talk about the conclusions and where we ought to be, and a little harder to actually recognize how hard it would be to execute on them.
So let's talk about that. But before we do that, let me raise one other sort of conceptual question, because I think it goes to some extent to what Kendra said, when you get to the issue of like how much has to be disclosed and so forth, but just sort of even backing up a step further, I found myself looking at this again and saying to myself, what's the trigger? What's the standard? When are we telling people to act and based on what information we're supposed to act on? And the reason I say that, and it's not a criticism of anything Eric's done, making the opinion a lot better, but I mean, one thing we're going to have to grapple with eventually is the consistency of what that trigger is, because we say different things. Sometimes we talk about the lawyer's impaired and it's impacting the representation. Sometimes we say the lawyer should do something when the lawyer, knows or reasonably suspects that there's an impairment. And so you get all these kind of questions. And sometimes it sounds like there might be certain things that could be taken care of through internal procedures and cooperation of the impaired lawyer and so forth, where maybe notice isn't going to have to be provided. And then if you do have to provide a certain type of notice, then you get to the question, and part that Kendra was raising, what exactly do you have to tell them? And it has to be balanced against privacy concerns and everything else. But just stepping back, I think we have to sort of figure out what's the trigger. I mean, so in the very first instance, I mean, and there is this process, I mean, and it's already in here, sort of, first maybe you're going to talk to the potentially impaired lawyer. If they're not, receptive to that or responsive, maybe you're going to go to someone else in the firm, and we talk about the two scenarios, how there might be different structures in place and different types of people you would go to do that. And there's kind of this progression, and then at the very end, it's like, maybe you even have to withdraw, especially this, lawyers and the junior lawyer or associate lawyers in this small firm. I just think we want to think clearly about what are the triggers of the, so for example, what's the trigger if I think that a colleague has a potential impairment? What do I have to do? Do I have to definitely go to someone within the firm, or I go to them first, or do I have to think that their impairment is actually harming, the representation? Because of course in this scenario one of these lawyers, or maybe it's in both, but one of the lawyers, he's really like the relationship lawyer. He's not really doing anything on the case, so we don't have much of a fear that that lawyer is really going to impair the handling of that matter. But I just think we almost have to think about it like in those steps, and what's the trigger, the standard. I mean, I would think just conceptually that if you have a lawyer who thinks that a colleague is impaired, and that has to be based on something, that is a decent reason to think that. You don't want people just running off, this person's having a bad week or something, and they were mean to me, and so I think they must be impaired, and it's like, whatever. But I mean, there's some standard for that, but I would think that whatever that standard is, if it's triggered, you would have an obligation to at least talk to that lawyer, maybe talk to someone else in the firm, regardless of whether what they're doing has any impact on the client's matter, I think, because there's at least the possibility, right? I mean, so I'm thinking of it in those steps, and I just noticed as I sat and thought about it, we have a lot of different things. Sometimes we say it's knows or reasonably suspects. Sometimes we talk about it's negatively affecting the representation. Sometimes we say likely to affect the representation. So I just think we have to be clear as we go through it about what the standard is going to be at each of these respective steps. I think, if I remember correctly, last time we talked about this opinion, we did talk about whether the standard is subjective or objective, and I think people kind of agreed that it was subjective. That, I mean, a lawyer in a big firm who has no involvement on the matter, has no interaction with that lawyer, has, maybe is in a different office, doesn't work with people that do that much work, they have no reason or knowledge about the potential impairment. It's hard to say that person should be in there doing X, Y, or Z, so in a sense it's subjective. But it's more than that, because I think we put in this, it's knows or reasonably suspects.
And that was language we settled upon.
Yeah, and
during
so,
the last discussion.
I mean, we dealt with that, but I guess the next question is, you know, once you have that, is there anything else you need? I mean, it seems to me if you have that, if you meet that standard, you should be doing something. It's not necessarily going to the client right away and saying that, you know, but, and I just think we have to be clear as we work through the sequence about what things are triggered when and what we have to do at that point in time. Yeah.
Are we contemplating putting the lawyer in a position to make what amounts to a professional judgment? And I mean not a lawyer's profession, but a mental health professional's judgment.
Well, I mean, that's one of the difficult issues. I mean, there's a reference to that in the current draft, and I think the reference is the fact that, and it may be off the ABA, one of the other opinions, I think maybe the ABA opinion that makes the point that it can be very difficult for lawyers to be able to appropriately assess, sort of in a clinical way, if you will, you know, the capacity of some other lawyer.
I mean, I'm down with the whole idea of our duty to keep the client informed, our duty to protect the client, but in essence, we're imposing upon the lawyer a duty to make a clinical judgment, which might in turn also trigger HIPAA protections and all kinds of other nonsense that we're not necessarily prepared to contemplate.
That's where I think it depends on the stage. If you say a lawyer has an obligation, if they know or reasonably suspect that the colleague is impaired, they have an obligation to talk to that person. I don't think that's violating any of that stuff. Or maybe even internally, if that person's not receptive, to talk to another lawyer or someone in management. I think you could say that certain things are required without, you know, going as far as
What
what
does
you're
it
saying.
take to be a competent attorney? Right. So you look at that ethical rule, which isn't all that helpful, let's be honest, but what does it take to represent a client competently? Don't get into what's causing the impairment, but just whether that particular attorney has the tools and the current wherewithal to represent that.
But here we get down to some of the nitty-gritty that you were commenting about.
Right.
I'm happy to cast myself in the role of old guy lawyer, the one who's possibly got impaired competence. So who are you, young person lawyer, to tell me that I'm not doing my job right?
Right.
And consider the social dynamics, the business dynamics, the potential defamation claim. I mean, we're talking really, really hard stuff.
Right.
And that also ties into the anti-discrimination element of it, so.
Right.
But if the opinion focuses, as Kendra was saying, on competency, then the junior lawyer is going to be pointing to specific things the senior lawyer has failed to do, didn't show up at court,
Right.
concrete things. So it's not a matter of diagnosing what the problem is and saying, you missed a court appearance.
Right.
You screwed up that deposition by failing to, and so the touchstone has to be the client is being harmed objectively. I've been fighting with this opinion in terms of that standard we tentatively agree. I don't think it's a matter of reasonably believes. I think it's objective reality. What's going on with that lawyer that you can point to?
But
Okay,
then
but
you
then
get
in
to
that-
this next step. So you made that determination, and then you have the confrontation.
Right.
Where this attorney is like, who are you? There's nothing wrong with me, you know?
But how do you
Let's
explain
assume
to
there's
say?
going to
You
be
missed
some
a court
healthy
appearance.
denial.
Right, right.
Now,
But you missed a court appearance. There's no explaining.
That missed court appearance is in here because we designed the fact pattern carefully. Absent that convenient fact, because it's not always going to be there. We're
Right,
trying to
it's
give
gonna be
people
implicit.
advice what to do in the real world, yet we're allowing ourselves the luxury of a perfect fact pattern where we have objectifiable stuff that they failed to do.
But I think that's the touchstone. I consulted on a case once where the senior partner was a heroin addict. But he had enough money to supply his habit. Another, came to see me, and is it objectively interfering with his representation? No. I was an education for me in terms of that. And the answer was, well, you're into the inter-firm stuff, and that, as long as the clients were not being objectively harmed, whether that junior lawyer talks to the senior lawyer about it is not an ethical issue. It's an internal politics issue, if you will, and I don't think it implicates the rules of professional conduct unless the clients are being harmed. And the junior said, no, they're really not big. This guy's he's a high-functioning lawyer, even though he was an addict, and it was clear. So that's why I think we need to stick with the objective
Oh, wait a minute. Are
conduct,
you saying
which
that
is why the
until
facts are
a
helpful
client-
here.
But are you saying that until a client is actually harmed, or at least in a situation where, depending on how other people behave, could be harmed, until we pass that stage, you don't have any duty?
I don't think so. I think you have to see harm. I think you have to.
Or how about the risk?
Otherwise,
The risk of
you're in
harm.
trouble.
I think you have to consider the risk of harm.
One of the notes I made, or,
Sorry, we're all talking at the same time.
okay, go ahead. No,
No, go ahead.
This is,
Go ahead,
I know
Jason.
my thoughts, I'd like to go ahead and hear everyone else's thoughts, so.
We have actually in B&P code a standard which is very helpful. Now it's kind of extreme because this is 6190, which are the circumstances under which the state bar would step in, is authorized, would seek court authorization to take over a practice. But it lists a lot of objective standards that the state bar would have to consider and the court would have to consider. And it's exactly these kinds of things. It talks about excessive use of alcohol or drugs, physical or mental illness, other infirmity. But so that the attorney has become incapable of devoting the time and attention to and providing quality of service for his or her law practice, which is necessary to protect the interests of a client who has an unfinished matter and for which there is no other attorney available. There's a lot of really objective stuff. We might even be able to reference this as what would be the ultimate conclusion, but it does provide a lot more and deeper analysis of the kinds of things we're talking about, and we may be able to leverage it.
I think that's a great point, and actually, I haven't had that much time to look at this stuff certainly, but I think some of the same kind of stuff, right? It's not coming from the rule, but from another source where they said, these are the types of factors or symptoms, symptoms is probably not the right word, but these are some of the things you would look at that might be a trigger or indicative of someone who's having an issue.
It's even better than that because it says these are the things the court would have to look at.
Yeah, right. No, I'm
If
saying
the
is
court-
or
if-
not
if
in the
court
rule,
would
but
be
it's-
authorized to step in,
it's the
these are the
same-
factors the court would have to look at.
Same type of idea as trying to give, I hadn't focused on that, that's a good point.
Some of the items that I had shared with Eric and Kendra were two categories. One were suggestions of types of illnesses, because people, I think, typically would think of impairment in terms of drugs and alcohol and mental impairment. So I had given a list for consideration. So the attorney is not required to make a clinical diagnosis. They may be informed of such things that could begin the process within that the attorney to analyze and consider. So they include cognitive and affective decline due to aging, due to brain injury or stroke, resulting from substance use or abuse, acute psychological problems or situational life circumstances, chronic mental illness, dysfunction due to physical illness. So those were just suggestions to sort of broaden the thinking of what one might look for. But aside from that, there are functional abilities that have already been mentioned by some of the committee today. And those could include a change in work habits or patterns, forgetfulness or lapses in judgment, failure to meet deadlines or to be accountable, failure to appear for meetings, court dates, and depositions, diminished quality of work product, personal use of trust funds or trust account overdrafts, personal credit problems, tax problems, liens, difficulties working with clients, colleagues, staff, and I have a few others. So those aren't professional diagnoses. Those are simply what I would call relevant functional behaviors that are relevant to the practice of law that would begin a discussion between an attorney who is confronted with these issues, and rather than ignore it, they could in turn decide to consult with the senior partner or the attorney in question. So Eric and Kendra has that. It's a decision as to how much or little you want to include those as examples if they provided guidance to the reader.
One other, and you may very well already have it, but something like bipolar mood disorder, which is treatable but untreated, it can get really wacky because a very high percentage of the matters that come through the discipline office are related to bipolar mood disorder. So if it is a known condition and that the firm is already aware of, and it is somehow obviously untreated or reported as untreated, that acting out, is something else that can trigger.
I don't think that the label itself should ever be dispositive for making a judgment on an individual. It could be a starting point, but I would think one would always have to look to the functional behaviors. There are many people. In fact, there's a USC law professor who's publicly acknowledged she has a lifelong serious mental illness. There's an interesting TED Talk she's done about it. She's an admirable, highly functioning person, but she has a serious diagnosable psychiatric illness that she fully acknowledges. But she's under treatment, she understands it, and it doesn't impair the quality of her work. So the label itself would not by itself be a justification for judging somebody has an impairment, including a bipolar disorder. Many people are fully compliant with medication and psychiatric treatment, and their own business. They may not want to disclose that to everyone in the firm. But if it became known in some in an accidental or inadvertent way, you would still always need to be looking at the functional behavior of the person before deciding if there's this impairment. And that speaks to Joel's comment too about risk for defamation for people to recklessly make erroneous conclusions about someone being impaired if one wasn't careful about how to treat the information.
There's another concern, and it still comes down to this trigger issue. Sometimes it's really, really hard to know or reasonably have, or have reasonable basis for knowing that there's a problem. Your high-functioning heroin addict is an interesting, colorful example of that, but it doesn't have to be quite that colorful. We've encountered a situation, which I can't discuss in great detail, but involved somebody who was seriously impaired by virtue of a depression that no one recognized. He didn't acknowledge it. He didn't appear to be non-functional to people who observed him or her, and there were no convenient, objective, you weren't there, where were you kind of things. So I think it's really important that we protect the client, protect the public from that sort of thing, but the difficulty of recognizing that, I mean, there are people who go to school for years and years and years to be able to do that, and we didn't. And even alert, sensitive people who are aware of the burdens that we all face in trying to protect our clients may not simply see that, and yet we're actually saying, yes, we're talking about imposing duties on all of us if we reasonably knew or should have known, but we're not really spending a lot of time on the reasonably knew or should have known part. And we did, admittedly, take sort of a convenient out in designing the facts here so that we can make our point. But we're not there yet in terms of giving advice to people. This particular situation I'm talking about was, it had really severe consequences for clients, but nobody really knew until the shit hit the fan.
Well, and to jump on that point, the people who are working most closely with the impaired attorney might see things, but it might not be readily apparent to someone who's not working with them on a daily basis on these detail-oriented tasks. And so when that junior attorney or the associate goes to management or their in-house counsel, those people might say, oh, I saw her the other day. She seemed fine to me. What are you talking about? you know? And it might be a harder task to then convince management to take some steps. And I think, and my advice to my clients always is to try to document as much as you can and go to management with some, you know, hard evidence of issues and mistakes to the extent you can, but it's not always, you know, a pretty picture. It's not always easy to do. So it certainly is a huge hurdle that has to be overcome. And that's the challenge with this opinion, is to, you know, express that in a way that's helpful.
But presumably the detail you would advise the client, the lawyer/client to get would be functional impairments, specific examples of behavior which,
right.
Yeah.
But just the existence of the behavior, or specific examples where there has been a negative or potentially negative consequence, even if averted, because, I mean...
That would be a narrower approach, which I would think. Right, where there's a negative consequence to the client, either obvious or potential.
But what troubles me about that is it becomes a very amorphous standard, and it's my understanding that what we're talking about is setting forth a reasonable protocol or set of standards that, including a series of triggering events, and I'm not hearing, I'm hearing conflicting views as to A, what the triggers should be. I mean, are we talking about the more amorphous concerns, but then that touches upon the shifting the burden on admittedly inexpert individual to make decisions as to the nature of a specific impairment? And, you know, to use your example, and I understand confidentiality concerns, but it would be interesting to me, you said nothing became apparent until the stuff hit the fan. I mean, then it's too late, obviously. And we're not giving any practical guidance in that regard. So it necessarily has to be an outcome-based assessment, but that is, it strikes me as inherently unsatisfactory because it's an after the fact, or it could be an after the fact analysis.
Just a couple comments, and they might be disparate, but I'll try to be organized as I can. I mean, one thing I'm concerned about the discussion taking place is I never envisioned this opinion to be the perfect answer for all problems. And I don't think this group should try to draft such an opinion because obviously it's a very difficult situation, set of problems. But it will provide great guidance, whatever work product we ultimately conclude. So just because we can't address all problems doesn't mean we shouldn't address any problems within the opinion. The other thing I'd focus on is the way the issue is currently presented, and this goes to Drew's point, which is what's kicked off this conversation. One is the activity on the lawyer who's observing another attorney's behavior become triggered. You know, it says when someone in the firm knows or reasonably suspects, whatever standard the group determines will be instructive. But I do think there needs to be a knowledge standard. And then the other part is that the colleague's representation is negatively affecting the client. So, you know, those are two parts within the same analysis, which is extremely important. So, to go to Joel's example, and you know, I understand Eric's concern. Well, it's going to be disappointing if we have an opinion that can't solve such a problem or address such a problem. But it doesn't have to be that someone's struggling with something for a long period of time and it's only learned about when it's too late. It could be, you know, someone's first use of a substance and, you know, they fail to show up at the hearing the next day. I mean, it doesn't matter, you know. The examples under which this problem could present itself are wide, vast, and varied. You're not going to be able to address them all, and nor should you attempt to. But if you just focus as specifically as we can, as you know, I think Drew's point was trying to identify a knowledge standard and the effect that is that the client is harmed and then we put in some specifics of things to observe. We shouldn't talk about bipolar or anything specific because we are not clinicians, we're lawyers. And I think you will have a great product which helps provide some guidance, which can present some problems, not all. I don't think we're attempting to address all. So again, my caveat was several comments not cohesive or closely well articulated, but I think if you have a knowledge standard and the triggering event is someone's negatively affected, you have to know, I would think, both. And you don't have to address every situation that can arise under the sun. This opinion would still be of great value to the profession. So, don't feel discouraged or frustrated or stressed that we're not solving all these difficult questions.
When you say affected, you mean risk of being affected, right?
Well, I think that's something to be discussed. I mean, so when I read this, there are a lot of steps in this opinion. So we're talking about many different things, and we should maybe talk about them sequentially to focus the conversation. But there could be, negatively affected, that's a knowledge someone's being harmed, we should do something, say something, that's clearest, right? And then the next step is, well, the client's not negatively affected, but I sure see, my partner or senior attorney or colleague is behaving erratically or very strange. And not only, I'm concerned for himself and for his representations of the clients, and that poses a risk to clients of the firm. I think both could be addressed and arguably should be addressed, but I think the difference is the steps you take are going to be different depending on you're addressing a risk to a client as opposed to actual harm to a client. That's the way my mind is looking at it. I think others might disagree, but when there's risk, I think that there are other protective steps lawyers or the law firm can take. When there's actual harm, their protection might be out the window, and there are corrective steps and measures that must be taken. And so I think those are two different approaches. I don't know if that answers your question, but that's the way my mind looks at it. And there's one of my concerns about the conversation is we're conflating a lot of things naturally. So I think we need to take it step by step, be methodical and clear. It's difficult, but I don't want us to become exasperated and frustrated. I think there's great content in here, and I thought Steve's suggestion on things to observe are helpful because, we're researching and discussing this, and we're aware of some of these things to look out for. A lawyer who's like, oh my gosh, I'm facing this for the first time, those steps and bullet points that are in an opinion can be really instructive and helpful for a reader.
So let me make a couple of comments and maybe a clarification too as well. So to me, this whole discussion, I think I agree we have to get more focused at a certain point, but I think it's actually beneficial what we're talking about right now. But it highlights to me my original comment, which is I think we need to think about this sort of in steps and triggers, because I think the answers are different, and the standards may be different depending upon what stage you're at, And so let me also say, Richard, to your earlier point, and this kind of gets to that, we weren't saying that it's all subjective. The issue about subjectivity was really the issue of almost like imputation, like when is the lawyer responsible to act? And we're saying that the knowledge that a firm is going to have is going to be through some lawyer or lawyers in the firm, and not everybody in that firm necessarily is going to have that knowledge. And we're sort of starting with a scenario where presumably a couple of people in close relation with the potentially impaired lawyer have that knowledge. Maybe no one else does. And so the subjectivity thing, I think, was really just, the lawyer over here who never deals with these people and hears nothing about it, and there isn't a facially, a facial impairment of the representation per se that's manifested itself, like a big blown deadline or something like that. It's not like sort of a strict liability thing where that lawyer's under some obligation right now to do something where they don't have any basis to know about it. So we're starting with these people who have some reason to know, they know they have very tangible, concrete evidence there's been real problems with this person, or they suspect it. And those people, we're saying, that triggers something. What we have to decide is, what is that trigger? And I don't think, and what I hear some people saying, I'm glad Kendra raised confidence, because that was my other big point. I had that some places in here it sounds like we're talking about competence as the trigger. Sort of what you can and can't do may depend on whether the lawyer is incompetent. But I think we need to think about it sequentially. I mean, I would suggest that we could tell the lawyers that suspect or have a reason to suspect that there's an impairment, that they should do something internally. Maybe it's just going and talking to that lawyer. You know, that's the first step. But I think we need to think about it sequentially. It doesn't mean right now you have to go tell the client and you have to disclose all this information, or you have to be a clinician. We're not going to turn lawyers into clinicians in this opinion. But I think if we think about it in stages, and as Andrew pointed out, I mean, when you get to the point, I think there should be certain things that can be done and should be done before there's any direct impairment of the representation at all. And I think that the opinion alludes to that. Sometimes internally you'll be able to take care of these problems. You know, maybe the lawyer's willing to get off the case, or maybe management agrees or cooperates, and you know, you get someone else in there. That may affect what your obligation is at the further stage. Maybe you don't need to tell the client. Maybe you just tell them, this lawyer is not going to be able to work on this case. You know, we're not going to give them all the details because of privacy concerns, but it shouldn't be that big a deal because we already had 5 people on the case, and this guy really wasn't doing anything anyway. And you know, we don't think this. You know, if the client asks, then we have to deal with that. But we're not going to go in and just say, you know. So I think if we look at it in that way, it's helpful. And to Andrew's point, I mean, once there's impairment, then it's dead. Then what's the? I mean, that's a different trigger, right? And maybe the obligations are different at that point, and that's triggering telling the client, and maybe, you know, what exactly do you have to tell them, et cetera. So I do think we should think about it sequentially. And Richard, I just wanted to make the point. I don't think anybody was ever trying to say that it should just be, you know, subjective. I think that went to what lawyers have an obligation to sort of act in when, if they had no involvement at all in the perception of the potential impairment.
Are you arguing then for an ethical duty to do something internally for the associate who's observing this, to do something internally before, short of harm, either actual or potential harm to the client?
Well, I guess that's the question, but as a first step for me personally, yeah, I'm getting to Steve's point, I think, where he's asking Andrew about, you know, risk. I mean, I think there could be some kind of standard that if the lawyer knows or reasonably suspects, and I don't think it has to be that the colleague has impaired the representation, but you know, has an impairment. I just put, this is the very first issues, but I put, what ethical obligations does an attorney in a law firm have when he knows or reasonably suspects a colleague has an impairment that could negatively affect the, you know, the I mean, I don't think you should have to, I know that's different than your view, Rich, but to take the first step of talking to that lawyer, or maybe even going to another lawyer in the firm, and I understand the defamation stuff, but I mean, you can go to management or another lawyer in your firm and say, I have a concern or an issue about something that's transpiring with another lawyer. In fact, all of us that serve as in-house counsel or risk managers in firms, that's encouraged. You tell young associates, this is the person. Or if you can't use this person, go to someone you feel is a mentor or what have you. I mean, I can't think we can't get so worried about defamation. So, but again, we got to look at it in stages. I'm not saying that a junior lawyer gets to veto what the firm thinks, but I think if we take it in steps, yeah, I think that junior lawyer should, at the very least, have to go, you know, either talk to the person they think is impaired, or someone internally, whether it's a mentor or someone in firm management.
And the hope is that you together will be able to figure out the next step. I think we have in here, the first step may be to confront the impaired lawyer. Maybe what we say is the first step is to, you know, bring it up internally, whether it's to confront that lawyer or to you know, discuss it with management.
To that end, maybe we.
Go ahead, Marshall.
Briefly, it just seems like the fundamental interest is, what is the duty of a young lawyer who observes that other lawyer will not adequately represent the client. The impairment's one reason they won't do that, but when I was risk manager at our firm, a lot of young lawyers would come to me and say they think they can handle this kind of case and they don't understand it and they're going to trial. That's a form of inadequate representation that I would want brought up. So I'm not suggesting you expand the scope of this article to something like that, but I think I'm agreeing with you. You should not, in this article, endeavor to try to clinically analyze the different levels of impairment. It's when a lawyer believes another lawyer reasonably believes some objective standard cannot adequately protect the interests of the client, whether it's in writing an estate plan, trying a case, whatever. And there's so many different permutations of that. If you have to be careful.
Well, that almost, I mean, that sounds to me like competence, which I think
it is.
Has to be in.
Isn't that what we're talking about here?
That's
Competence?
that's one of the factors that's in here, one of the triggers. But right, it's at a certain stage in the process. Anyway, we had a bunch of hands.
I just wanted to emphasize Andrew's point, which is maybe it's if we divide it into two separate categories. One is risk management, and the other is damage control. Harm has happened already. What do we do to fix it? Harm might happen. How do we stave it off? And maybe that structure will help address a lot of these concerns, and then it can be like stepwise through each of those categories. Maybe then we can talk about what is triggered along those two lines. And that might simplify the discussion, because all of these things, it might not, it might be actually more messy, but so I mean that was just one thought I had, that that might be a way, because then the question of client consent also becomes an issue differently in those two kinds of situations. And that was one of the things as I was reading through this. There were moments where client consent was talked about, but it wasn't clear why client would need to consent when you're just shifting the internal staffing. Maybe there are circumstances when that does need to happen, but maybe there aren't.
I think you're conflating two different things, in my mind. One is the clear ethical issue. The ethical issue is to intervene at some appropriate level within the organization when a client is being harmed by incompetent representation, as objectively observed by functional problems. The other is the human urge, need, desire, whatever, to look at a fellow human being who maybe or may not be your superior, whose behavior is problematic. And those are different to me. That's not an ethical issue. That's a human issue, a human relations issue, a risk management issue, which people will no doubt want to act on or not, depending on their courage and the firm culture and all kinds of things. And I think that's not an ethical issue. If you suspect that there may be a problem with a partner, there's no ethical obligation for you, in the absence of demonstrated harm to the client or likely harm to the client. I don't think that's an ethical issue. That may be, again, a human issue and so forth. But so I think that we're going to be writing a much too broad opinion if we talk about like that initial stage. Much too broad, and it creates, I think, an ethical obligation when there isn't one. And that may be troubling to folks reading this, dealing with who may be dealing with an impaired member of the firm. It bothers me.
I'm a little confused each time I hear you say this, Richard, because if you think that the trigger is client has been harmed or potentially may be harmed,
right.
I think we're all in agreement. I think that's everyone thinks that.
Right.
I thought where you were coming from first is that there has to actually harm has to actually have occurred, and is that
objective conduct has to have occurred, which either has or may harm the client.
Well,
there has to be objective.
Wait, how can conduct have occurred which may harm the client? If the conduct's already occurred,
Right.
it has her harmed.
No, not necessarily. I mean, a lawyer can miss a court appearance, and the judge could be on their stand and say, all right, we'll continue it for a week.
So you think what's key for you is there has to have been some kind of conduct
Right.
that's not, but of course the conduct can be, like the conduct is lots of things. Like the conduct can be weird comments in a meeting that are completely off point. Is that conduct?
Sure.
Okay, well then I don't think any of us in the room really have a disagreement.
That's what I'm trying to uncover. But I'm hearing Andrew say, well, let's talk about the steps. And the first step would be you don't have necessarily any conduct. You just see some evidence of impairment.
Well, evidence and conduct are the same.
Right. How can you? There's
conduct is the evidence.
Is the behavior of the lawyer.
But what if it's like inappropriate remarks in a staff meeting?
That's conduct.
Could be, could be.
So I guess it is so there's some conduct
now
that you have to deal with internally, but may not be something you have to tell the client.
Oh, what's a second? I'm not.
Right, so that's the first step. And then the second step is, has that conduct risen to a level that is a significant development in the case, and therefore you must tell the client.
Right.
So that's step 2.
Right.
And hopefully with step 1, you have more than one attorney, that can help make the decision as to whether the client needs to be informed.
Part of the difficulty I'm having, I think, might be underlying some of the concerns being raised around the table about the direction of this opinion is how we each view the purpose and function of an ethics opinion. Is there an ethical duty to intervene? What authority tells you got to do something when you only suspect risk or potential harm to the client? Whereas I think we're more in agreement and on solid footing when actual harm has occurred. I think we're more, as a group, my sense of hearing the conversation is that there's greater consensus and probably a better ability to write an opinion about when the harm has occurred. And this is just an idea. I don't know if I personally endorse it just came to my mind, but something to think about is we could flip the two in the opinion. Address what we know first. When actual harm has occurred based on the impairment of a lawyer, here's the obligations of the lawyers and the firm to address that harm. You address that up front. I think my sense is the group, again, there's greater authority and we could probably come to a better group consensus as to the conclusion that would be reached there. And then we transition to Roman numeral number 2 and maybe some sort of disclaimer. This isn't an ethical duty, this is just guidance. What to do if you suspect someone in your firm might be impaired or going down the road of impairment. I don't know the right words, but then we get practical advice of what lawyers and the firm could do to help address an issue that has not yet resulted in harm.
Isn't that a totally different opinion?
Yeah, that sounds like.
I don't just mean in order. There's never been anything in this opinion about a mistake having been made. First of all, that's like a different opinion. This opinion has always been about one if nothing has happened yet to the client. Like I remember our fact pattern has always been junior partner bobbles the hearing, but associate steps in and equity partner hasn't done anything except for be a little goofy, right? So that's our opinion. What you're describing is just a different opinion.
Yeah. With all due respect.
That's fair. Yeah, I mean, again, I'm not saying it's the best idea. Just throwing out an option, but I don't disagree with what you guys said.
Well, and just to be clear, I mean, to your point, Richard, I mean, there's nothing happening. I mean, it's different to say there's really no ethical obligation if you observe some other lawyer and you just think they're a jerk and nothing's happened on the case or anything like that. So there has to be some, that's why I'm focused on what's the trigger. But it seems to me there's certain conduct that could occur that has not yet demonstrably impacted the actual representation. but raises a flag. And to say you as a lawyer don't have an ethical obligation to do anything about that, if and until it, has some tangible effect on the representation, I just don't have that much problem saying that, at least in the internal construct of a law firm, when you have conduct that creates a flag, yes, you're not a doctor, but you should do something about it. And what you maybe have to do at that point may be limited, but saying that you should internally talk to that lawyer, talk to someone else in the firm. I mean, I think we have obligations as lawyers to try and protect our clients. And, we do that a lot. And sometimes we're right and wrong about the worries we have on behalf of the client and so forth. But, and I don't think you have to be a guarantor. I don't think you have to be a clinician. But it seems to me that you can say that lawyers internally should be, they have some, it has to be something that is reasonable. You have to see some conduct. It hasn't impaired the representation yet, but some conduct that reasonably could be indicative of an impairment that could cause real harm. We're trying to prevent that. In fact, the opinion talks about it. We say all through the opinion, you have these obligations to try and take steps to protect the client. Basically, so that then, if there is truly an impairment, it doesn't get to the point of having a negative, substantive impact on representation. So, I don't know. I mean, I also agree the opinion is different. I still, personally, I kind of like the sequence. I mean, which is already sort of how. Why can't this opinion has never had actual impairment of the representation? You start by talking about, at some level, if there is conduct that is a reasonable, signal of the possibility of someone having an impairment that could harm the representation, you take the following steps. And we can get on the back end, and I think we kind of do, to the point, and I don't know how we shifted exactly, but and if there's a point at which there was actual impairment, that this is here's what you have to do. But it makes more sense to me in the sequence we have now, quite frankly, flipping it around, not the beat on that, but yeah, Steve.
Yeah, this has been an incredibly rich discussion, and I haven't absorbed it all yet. There's a lot there. One thing that strikes me is that, first I went back and reread the opinion. It's really striking to see how it ducks all these issues. First of all, it writes it as it's only written in terms of knowledge, and it doesn't say anything about what, it just doesn't talk in terms of concrete particulars at all, in any way that are being interested. And to me, it provides very little guidance beyond sort of saying, well, there exists a situation where you would know. And then you have to do something. We doesn't do anything with should know, and so we're doing something that's way more ambitious in terms of potential. No, I mean, I'm just saying it's working, but so I'm just giving this some credit and also thinking about why it's so hard and all the things everyone's been saying. The thing that strikes me about impairment that might be different in some ways than what Marshall was talking about, the sort of general ability to do competent stuff, is that impairment seems to me, it's like, we always think about, the exercise of judgment. And exercise of judgment is sort of immune. If the lawyer has actually exercised judgment, right, then as a practical matter, they can't be sued for malpractice. A lot of what we're trying to get at here is the situation where the governor is busted, right, in some way, and that you can't trust that lawyer's judgment anymore, right? You can't, the basic stuff, something like that. I just, that's just maybe not very helpful, but that's part of what strikes me about why impairment might be different in some way. And then I think it's just inescapable that I don't know how you order the opinion, but Eric's got it. Well, it's mostly there, what we can say effectively. There are three options. They're the ABA options. They're internal action, right? And there's telling the client. Reporting to the state bar, mandatory reporting is not an option, doesn't exist in our scheme. So it's basically internal action and telling the client, right? How's that? And what's the trigger for internal action? It's got to be conduct by the lawyer, right, of some kind. And then we have to talk about what it is, but it's something like, whether we want to go beyond knows, we should really talk about. Whether reasonably should know is a trigger as well as something we should really think about whether we're going to do. And then impairment, I think we're going to leave basically a blank in certain ways, probably in the way that the ABA does. It's going to be tricky for us to try and go very deeply into what impairment is. And then there's got to be a risk of harm, some kind of specification of the risk of harm, how big it has to be, how big it has to be, how big the harm has to be. And then it seems to me that that's what we're going to do, what we're going to be able to do. And I think we're actually a lot closer than we think, because there isn't as much as we can, there isn't as much that we can do as we can't, there's a lot we can't do. One last point, which is, it's very strange to be writing this opinion about a junior lawyer, right? And not to be talking at all about the question of the sort of question of when the junior lawyer has a right to rely on the decisions of their superiors, right, in making an ethical judgment. California doesn't have that rule yet. But what?
Yet.
It's going to almost instantly.
Right.
Right? And it doesn't have it yet, but on the other hand, it must have it. I mean, if there was no rule, like no proposed rule 5.2, and we were advising any of us were advising a junior associate, we would tell them, we bet you State Bar is going to give you a 5.2, because otherwise, how do you deal with the issue Joel is raising, the professional suicide issue? It can't be the case that if you're senior, you disagree with your senior, right? That you have an obligation to go to the client in every case where you disagree with your senior. That just can't be right. Is that what you would advise people? I would say that, or in any event, do we want to write an opinion as if there's no issue there? Right?
It's so funny because this has been the issue. This takes me back to my very first year in co-practice. I don't know, 4 years ago, and this is Jennifer Becker, who was the original writer of this. No, she wasn't, but she had a particular bugaboo about this opinion. And she was always concerned about issuing an opinion that told junior lawyers that they had an ethical duty to go running to the client. And I always thought, she had a real point. I mean, you could create real great, there's all types of people in the world, including some very entitled feeling young lawyers. And this
what generation?
Just any, mine. Sorry, I jumped in.
Sorry.
So I think what Steve is proposing is a super helpful and also, is a very appropriate and also a super helpful addition. That just maybe even a paragraph where we talk about the ability to rely. And I really find jarring in our current opinion the notion that one of the duties may be to withdraw, to basically quit the firm. That just always, I feel like if we issue an opinion like that, people are going to say, co-crack, you're like crazy.
Yeah.
I just have a comment about sort of the factual, just a minor comment about the factual scenario and whether we wanted to move away from the fact that there's a trial 30 days away in the second fact pattern, because I feel like that sort of adds this level of urgency to what the attorney may or may not have to do, and I think it implicates issues of withdrawal because then that's going to likely prejudice the client, and I think that maybe we can have a more reasoned approach to dealing with this with triggers like we talked about, where there's not this imperative of trial 30 days away. I mean, perhaps it's that they're preparing for trial or something and that they're in some unspecified date in the future. Obviously, having competent trial attorneys representing the client at trial is really important, but not that it's this 30-day deadline, because I feel like this kind of would invoke panic. It raises the question of when did this junior attorney learn of these markers, but then also yeah, right, 30 days away, what do I do? What do I do first? How do I tell the court? And I think that maybe we can, that's just this idea.
Yeah, that's a fair point, but I think that's a carryover from when we just had one scenario with a small firm, and that was intended to add an element of urgency.
Right, yeah.
Just on a point of clarification on the withdrawal question, I understand that you're talking about withdrawal of the firm and no longer representing the client, because sometimes it looks in the opinion like you're talking about withdrawal in the looser sense of the attorney who's impaired no longer working on the case, as opposed to withdrawing under 3700, no longer representing the client.
I think it kind of talks about both.
But this
is I think some clarity with what I'm saying would be helpful in that area, to say, there are two types of, or two arenas of withdrawal that we're talking about here, not just the mandatory and permissive, but the withdrawal of the attorney, not from the firm, but from this matter, and then the firm from the client. And then you have, then at that point, different levels and types of consents and information, that has been given to the client, and different types of consents that the client has to consider for how to restaff the trial team, how to, is it good to bring somebody in from outside if you don't have anyone in-house to take care of it? Should the firm withdraw altogether? And then if you're talking about the consent to bringing in someone from outside with the impaired lawyer loosely withdrawing from the representation, then you've got a potential fees sharing type of information and consent that also has to happen. So it just seemed like it doesn't have to be much, but just some clarity in that area might help.
Yeah, I mean, when I read, I thought when we at lines 229 and 30, where we say, as a last resort, withdrawing for the representation. If this is, we're talking about attorney, and the junior partner and the equity partner won't acknowledge that anything's wrong, I've always assumed that just means the attorney quitting the case, or quitting his job, or, because it doesn't seem to be within this scenario that he can control whether the firm withdraws. So I just am flagging that as a lack of clarity in our current draft.
I just echo something Steve said earlier, but Eric, I agree. I think most of what can go in here is in here, and so my whole comment at the beginning that started this was just that I think in terms of moving forward, focusing on it and further revision, we should try to think about it very sequentially at this juncture, and sort of, the standards, and at each point sort of reach our consensus. I have one other just quick general comment, which is a couple of places we talk about the fact the equity partner is kind of the relationship partner. He's not really doing much in the case, so he's the one we're less worried about really having any effect, quite frankly, on the litigation. But you make the point, which I think is a good one, that we're not sure, as another lawyer, as a junior lawyer, we're not sure what other cases that, maybe he's not doing anything substantive on this particular matter, but I think you make the point essentially that, should look into or find something out about, what other cases he or she is working on, because maybe there are other matters that are potentially at risk. And I would just say, it's mentioned 2 or 3 times, and where we mention it, I think we should make the point that that equity partners, one example is line 84, the red line, does not know the extent to which equity partner may be engaged with client on other matters. I think sort of throughout it, we should be making the point with client or other firm clients on other matters.
Right.
We're just missing that extra piece, which is may not even be this client's matter that I'm working on, but if this lawyer has a potential impairment, they may be working with other clients in the firm, other than this one. Not only different matters for this one, but other clients completely, and we may need to go do the types of things this is saying in terms of looking into that. I don't know, is that helpful? I mean, I guess.
It is very helpful.
From a drafting standpoint, I think we could almost start, instead of trying to read the whole thing, just take stages at this point and try and, here's the first part, and we get some sort of definitive agreement on the trigger and of that, and then you go through it like that. Anything else from anyone on that opinion? All right.
Just one second. Look at my notes, make sure.
Yeah. Why don't we do another opinion, and then we'll see where we're at for what is it, on the 3:15 break, something like that. Okay. Richard, how about the Stone laptop?
Wonderful.
All right, so 16,002.
Give me the page number on this.
We're going to have 100 opinions in a year.
I think it's 59 to 72.
Can you make an executive decision to change it?
16,002?
What do you use? Roman numerals?
Yes, 16,002.
Right, just a number.
Page 65.
How about anything that goes beyond a certain number gets renumbered? Okay, so this, Richard is the lead drafter on this, and then our subcommittee is Eric and Rishvala and also Suzanne.
First, thanks to Suzanne for suggesting a conference call. This is extremely helpful, and I urge other groups to take advantage of it. And thanks to Eric's firm for hosting the conference call, has the setup, for it. It's effortless to do it, and it's a great way to make it efficient. As you can see, we've moved beyond Robert's outline. It's obviously appropriate to begin actually drafting something. So we've eliminated his outline structure, and it's organized under the 3 rules. The first is the duty to inform the client of the theft and loss. And the bulk of time is spent discussing whether that's a substantial development. And then the second point of that is if it falls within the civil code section regarding the unauthorized access of certain electronic data in civil code section, that's a mandatory reporting statute. So we end up with that under that section of duty to inform the client. And then there's the duty to safeguard confidences, and that, according to one ethics opinion, that really becomes a duty of competency. In other words, the duty to protect confidences is one of the acts of competency we expect. And then under competency, the consensus of the drafting group was to eliminate all references to standard of care, which I agree with, and focus on the ethical issue, which of course is competency without getting into the standard of care. My first draft, you might have remembered if you'd gone through it for the last meeting, listed what I call deficiencies, like unencrypted data, easily hackable password, etc. And the committee thought that, well, that was inappropriate because that smacks too much of malpractice and the standard of care, and I agree with that, I see that, and so that I just basically have one short paragraph. And I'm calling it now problematic. I'd like your feedback on whether you think that's still too much in terms of standard of care or whether you think that's appropriate. The purpose, I think, is to alert lawyers that there's malpractice in the air. When you lose something like this, that's so easily hackable, and if a client is harmed by an unauthorized user, there's clearly a potential malpractice claim. So that leads into 2 points. One is the footnote about contacting your insurance carrier. I think that's important to leave in. I talked to the lawyer's mutual underwriter, and she said that we expect a lawyer who's lost something like this to tell us immediately, because they take steps right away to start to assess the harm and take ameliorative steps. So I think that's worth mentioning, and I likewise think lawyers should know that there is a potential malpractice claim, and here's the specific conduct if it harms the client, which could be the basis of it, which I deal with in that one paragraph. So I'd like your thoughts, of course, on that. Obviously, whether you think we've dealt adequately with the substantial development issue in the first part, or whether it's too much, or certainly like your feedback on how, what does it read like? Is it adequate? So, thanks again to the drafting committee. And let's hear from you.
Okay. Well, let's open it up to the subcommittee then, I guess. Eric and Vala, you have comments, and then just more generally, we'll get everyone's comments.
All right, so do you want to go first?
Go ahead. I can throw
So-
a comment, but go ahead, sorry.
No, go ahead.
I just looked up the
Yeah, no, no,
Just to one of the things that you said, Richard, in terms of the substantial development, and I think you said something to the effect, we're interested in whether you thought it was too much or something that. I had a thought that struck me as I was reading it, which is, in terms of the organization, maybe confidentiality should be the first thing that we discussed. I mean, you've laid out these different kind of issues or obligations that are at play here. I'm just posing the question, but it seems to me it might make sense to deal with confidentiality first. I felt like with the duty of communication first, we spent an awful lot of time trying to justify whether it was a significant development that we would communicate to the client. And I sort of feel like if you have an obligation to protect the confidential information and that hasn't occurred, not purposely, but just by, using these devices, what have you, and putting aside possible liability and so forth, I mean, it seems to me pretty clear that, and that information is at risk, potentially. It is confidential information, maybe in the hands now of someone outside the attorney-client relationship, maybe accessible to them. It seems to me pretty clear that that's a significant development. And so I just thought, conceptually, it seems to me like maybe confidentiality is the thing that comes first. And then I also thought if that were the first thing we discussed, we don't need to spend so much time on whether it's a significant development. It seems to me it kind of flows out of it. You lay out, here's the duty of confidentiality, and includes, taking reasonable steps to protect confidential information and so forth. Even before the notice, it's the big ticket, one of the big ticket duties here. The communication comes about because of the possibility that that duty isn't satisfied, it isn't complied with. And the notification flows out of that as well. So I just thought structurally, when you have confidentiality here, I just thought structurally it might actually help to deal with that first. And while I commend you guys for trying to, nail down the communication, I just think it'll flow out. We probably don't need the volume of discussion about it being a significant development once we sort of establish that what the duty of confidentiality requires. Now this information's at risk. Here's what the duty of communication says. Yes, it would be triggered. You have a notification obligation, and then what does the notification obligation consist of? and I don't have any, I throw out some other comments and tell me to shut up whenever you fall. Shuffle through. But, and these are kind of not necessarily all in order, but, so another point I had to myself is, we talk about the notice obligation, but it seems to me we're gonna have to, at some point, wanna get more detailed about what the notification would be or should be. For example, you know, do you have an obligation to give them some information about the ramifications of the fact, you know, in other words, not just, I need to let you know I lost my laptop and it might have your information, but, you know, that might be, you know, that was confidential information on it, you know, that could create issues with privilege, et cetera. We've got to do whatever we can. I mean, I don't know what the full parameter of that notice obligation is, but we need to think about that a little bit. It might be more than just saying, hey, I lost my laptop. We have to give them more guidance than that.
I couldn't find any support for that. That's a very good point.
Well, I don't know.
If anybody knows, yeah, of any.
But I mean, I could see a client hearing you
Asking.
say that and not realizing what that could mean to the
Yeah,
information.
consider it, sure.
And then there are some opinions in authorities and resources that talk about, you know, the obligation, some say it's an obligation, but that, you know, to what extent you have to talk with your client about the way in which you're gonna manage the information, sort of up front. Like that it's, you know, you should be having, they should know how you're gonna, you know, control their information or manage it. I don't know, that may get too far in the field here. And that also has to do with the sensitivity of the information, all that kind of stuff. Another thing, and I was trying to poke around and look to see what other resources had said about this issue, and I don't know if you did this, like I was trying, and I did it quickly, to see if there's been other ethics opinions that deal with this issue, and I couldn't find, I mean, the opinion you have in here, which I think is the New York State Bar opinion, that's like a destruction of records. It's not really quite the same thing, because the information's gone.
That stemmed from Sandy.
Yes,
Hurricane
the
Sandy.
risk in terms of that information falling in the hands of someone, that element isn't really there, which is the big element here, right? So anyway, I saw Steve shaking his head.
No,
saying there are no other opinions. How?
I recently had occasion to look at that, and I couldn't find it anywhere else in the country.
Yeah, and I didn't look at it very thoroughly, but I couldn't find anything, and I had the same answer. There's got to be an opinion out there that's talking about losing your cell phone or losing your laptop.
We're writing the first one.
Okay. But one thing I did see in some of the things I looked at is that we don't talk about in here, and just conceptually is something to maybe think about, is, you know, this sort of, they'll talk about supervision.
What sense?
Well, and I think you touch on it to some extent, but I mean, it's not, do we want to talk about the fact that, you know, the lawyer's obligated to take reasonable steps to keep this stuff safe, this information, and those obligations would flow from the lawyer to other lawyers in the firm. I mean, you kind of touch on it, you say that, I think you say that the firm has a policy or something, that you only do certain things with the information, only download certain type of information, then you'll get rid of it or something like that. And the lawyer, I think, has not done what they're supposed to do.
Well, I covered that under competency during passing.
Right.
You know, maybe we should expand that.
I don't know, I was trying to see what I could find out there in terms of what people identified as the issues that would go into a scenario like this. And supervision was just something that got mentioned a couple of times, so I don't know. And maybe it's worth, you know, saying something about it. But I do think we should make some reference to, you know, in the context of talking about lawyers' obligation to try and protect this information, you know, that we have to take certain reasonable measures to safeguard it, which is like in the commentary to the ABA model rule. Right. What else?
Would that be though within the duty of competency, or do you see it as an addition of another duty?
Well, in the model rule, for example, they're talking about it under the duty of confidentiality. It's what is it?
Well, certainly the
Duty
duty
comment
of
16 to 1.6 or something.
Right.
But I mean, it does kind of, the competency aspect starts to mesh with the confidentiality aspect a little bit. But that, again, structure-wise, that's why, to me, it seems like confidentiality, you know, which sort of bleeds into, you know, the competence, has to talk about, you know, the reasonable protections that you have that obligation and sort of competency, and then it flows into, you know,
Notify.
what's your notification obligation, and that kind of raises the question, what do you got to actually tell them?
Good suggestion.
But those were just, I was just thinking about things sort of structurally. Those were some comments. Yeah.
Structurally, I agree. It makes sense to go confidentiality first and then flow the communication out of that. And I think the section on confidentiality does need to be expanded a little bit and clarified. And this is something that we discussed to some extent, but 6068 E has two things in it, which is maintain and violate the confidence, which is not confidentiality or confidential information, and then preserve the secrets of the client. And I think 3100 in saying A, that the member shall not reveal information protected from disclosure by 6068E1, is referring to preserving the secrets and not the maintain and violate the confidence of the client. So I think that distinction should either be explained, or that the reference should be to preserving the secrets and not commingling the concept of confidence in 6068 with the concept of confidential information in 3100. They're two separate concepts. And then in 3100, then a further discussion of the difference between the client's secrets, which is the reference to 6068, and 3100B, which is confidential information relating to the representation of the client. Again, a different type of confidential information. And so I think it would help to spell these things out a little bit better and develop this duty of confidentiality in the context of the loss of client data. And it happens often that you have client data that may not be exactly necessary or focused only on the area of representation. You might have more data than you might need because you gather it. And one way I think it will help, just parochially, I know this, a lot of smaller firms tend perhaps not to pay so much attention to data breaches. They don't think about it. Well, I don't have very much information. I'm not going to worry about it. What information could I possibly have? And so I think a little bit greater guidance on how these different types of information fall into these categories of secrets and confidential information and so on might help to some extent. That's just an aside and a tangential point, I think.
On that point, I'll just quickly say, I made a note, there's a couple places where it seems like we're using the secret and confidence language, but we're not. It's like too narrow. I mean, the discussion, the duty of confidentiality, we should start at the broadest.
Yes.
And secrets and confidence are part of that, which I think is what you're saying.
Right.
There's some places where we're kind of just quoting the
exactly
snapshot of
the statute.
What's a secret, essentially.
Right. No, I agree. So start with a broader discussion. I definitely agree with that. And then that would then, flowing that into the discussion of what's significant development, what should be revealed in this discussion can certainly be streamlined a lot, because the cases that are referenced are not all on point of fact. They deal with different types of situations. What is a significant development, and then they're not about loss of client data often. It's different types of factual patterns, but they all have some kind of a related policy issues, so I think it would help for those cases to focus in on what the underlying grounds are.
Underlying ground, you mean what the specific facts are which triggered the duty?
No,
conclusion?
what the policies are, right? Because it's the policies that tie all these facts together. These
Right.
facts don't matter for what we have, you know, I mean, there's a whole
Agreed.
page-long discussion of facts that is completely irrelevant for this discussion.
The policy
But we
that I
have-
did point out is the fact that each of the scenarios which were held to be a significant development involved a choice the client had to make.
Right.
That's what unifies all these cases, all these opinions.
Right, and so
Is that-
you can start the discussion from the policy rather than from the facts, because here the facts are not on point at all.
That could shorten it. yeah.
Right, and so you have the policy, and even here, there might be a different way to talk about the policy. I haven't quite thought this through, but, because it's not really a choice here for the client, are you gonna continue to hire this lawyer? It's, what do we do with the loss of data? Different issue. And so here you're focused on the policy of what, this is the choice of the lawyer, I mean, choice of representation. Should the client continue with this lawyer as opposed to someone else? Should the lawyer fire it? And so there's this, should the lawyer be fired? And so there's a sense in here that you're reading it, I was reading with some alarm, because it seems to be suggesting that if the lawyer inadvertently loses his or her laptop or a briefcase or something, then you should worry about the client firing them or losing their data. Might happen.
You should worry. That's the
But-
point.
No, but I think that policy consideration doesn't fit these facts as well. But, you know, that's just.
No, I agree.
In the sense, give me more, I guess I'm not sure what to do with that. If you,
Can I, because I had the same reaction. I think the reason the client, the primary reason the client wants to know that its data is out there in the world is not because they got to decide whether to fire the lawyer, but they got to decide what to do about the problem that their data's out there in the world.
True.
Now, and even if you knew somehow, even if you had a conversation with your client who said, if you ever lose your laptop, I'm not going to fire you. That would not tell us, well, you don't have to tell them, right? So I also had the same reaction, which is these, you know, I don't have a very hard time getting to the conclusion that unprotected loss of sensitive client information is a significant development. I don't actually know that we need to spend too much time belaboring that, because I don't think very many people are going to really question that. I'm not saying that we shouldn't have some authority, but one, I don't know that we need that much.
Okay.
And two, I don't think the authority necessarily we have in here gets at the heart of why this is a significant development, as we all kind of feel in our gut. And yeah, and I had the same reaction. I was like, what? Someone steals my laptop? Then they, you know, I'm incompetent?
Yeah. Well,
Well, there's two pieces. I mean, it's, one is, it seems to me that it could be clearer. I've talked to some lawyers who think about this a fair amount, and their view is, you know, I mean, if you lose an encrypted laptop,
That's different.
right, it's totally different. And I think we should be clear, you know, that if you've lost something you can turn into a rock, as one lawyer said to me,
right.
Yeah.
right? Or that is effectively a rock, then there's really, there may be, maybe that needs to, maybe that's clear enough for everybody, but.
Do you think that should be made clear here?
I think so. I think you should, I would think that's like, one thing, it just gives everyone a lot of relief. Like, it doesn't mean you have to keep, you don't, as long as you do the right things, you can take your laptop out in the world. And it's actually one of the reasons why this is so egregious is the lawyer's failure to take, you know, what today are really very simple precautions. But yeah, it came across to me, but since it didn't come across to you, Steve, I think maybe we should sharpen
I'll
that.
certainly add that, that's to me.
I just did that, and yeah, anyway, that, other than that, I think the discussion is, confidentiality is the key. And that duty to communicate indicate triggers, it may trigger off of, it's less about I should be fired. That if it's malpractice, if we've already decided what they've done is committed malpractice, whatever that means in terms of acts of malpractice, which might include damages in some people's view, right? Then you've clearly got a duty to talk about it anyway. But the critical point, it seems to me, is what people have been stressing, which is that the client needs to know, because the client needs to know how its work has changed, right, in some way. How the disclosure of this information might have changed its situation in a way that it can do something about, or that the lawyer, together with the lawyer, it can do something about. And I think your identification of the underlying policy is very important there. Because even if there's no malpractice and no issue of continuing the attorney-client relationship, at least in many, many instances, right, depending on the nature of the information that's out there, there will be something the client can act on.
Just as a follow-on on that, if we're going to raise the malpractice issue, and this is at, I think, 157, 158 of the red line, I think we cannot just leave it at obligated to tell the client the facts giving rise to a malpractice claim. You actually have to advise the client of the consequences, I think, a little bit further. So if we're going to make that if we're going in that direction, then that needs to be spelled out a little bit more. If we're not going down that road, then this is unnecessary, because in this fact pattern, we haven't really gone in the direction of, well, one, we're not going in the direction of malpractice claims, I think, and the duty to disclose facts related to error, unless we're going to shift it in that direction, as Dee was suggesting. And in that case, we need a more robust discussion,
Right.
of what that disclosure is, not just facts, I mean, that's very surface. But I think it's not really, we have to decide if that's the scope of this discussion or not. I don't know.
What's your point? Yeah, should we go into more of the malpractice issue?
Well, I mean, if we're going to take the position that it should be, that losing the data is tantamount to is that type of an error. Maybe sometimes it is, maybe sometimes it's not, but then you need a different set of facts, I think, for that. I don't think we've gone in that direction in this opinion. But if we decide to do that, I think that has to be.
Well, doesn't it
Well,
depend, sorry.
I'm sorry, the malpractice issue, the standard of care issue is really beyond the
No,
scope of
but
what
it'll
we do.
be the question of disclosure.
I mean, I
That's
agree with
what
the
I'm saying.
disclosure, yeah, I mean, I think
I'm not talking
we're
about-
jumping
Yeah,
to
but
conclusions with malpractice, because we don't know under these facts whether, like, I mean, I do think there's the duty to say, like, this is what was the circumstances under which I lost the computer, this is the information that was on it, this is the type of information it could
Here are the
impact you, here's the
consequences.
consequences, but we don't know that it's gonna fall into anyone's hands that would do anything with it that would cause any harm to the client. That's kind of a premature
But the client will
conclusion.
necessarily incur costs to
Yes.
safeguard that data, which gives rise to damages component, so.
So I mean, there has to be a little bit more robust discussion maybe of the consequences of this, and not just say it's facts giving rise to,
Except that there are other opinions out there addressing the duty to disclose facts giving rise to possible malpractice, or whether you have to say the M word, and there's a lot of opinions about
Just
that.
another one from this committee.
Including another one from this committee.
I agree.
So
So-
I think we can address this issue and not tread on those other opinions. It's-
And I'm fine with
I,
that.
I,
Yeah,
I
I'm fine.
think the idea of focusing on the obligation to protect the information, the obligation to notify so that they know how their world has changed, so to speak, and also something that's not in here, which, and we may have sort of written the facts in a way, and I'm just throwing this out here, but it's kind of a fait accompli here, that there's nothing that can be done. You know, it's lost and the end of the story. When I've seen these scenarios in real life, sometimes it's less clear, and those are the situations where the lawyers are looking for more guidance, you know. And it kind of gets to Steve's point, the facts were a little different, where there was a possibility of certain things being done that could nullify the threat to the confidential information. That's helpful to say. It's also helpful to know. And I'm not talking about a big tweak, and again, just throwing it out there, but maybe changing the facts a little bit to accommodate that. I mean, there isn't any discussion here, and what comes up a lot is stuff like, well, I think there's a risk to this body of information. Some person left, or someone had access to something, and they may have copied this, or they may have gotten this information. Do I have to suddenly go out? And I have no idea. They may have done it for reasons that have nothing to do with the clients. I don't know that they even know the clients, but still, my client's information is exposed. I think someone outside the relationship has it or has access to it. And one of the first questions is, well, do I have to immediately call up every single one of my, 2,000 clients because our billing, software system is somehow encapsulated in some download of information that someone did from the system or something like that. And so sometimes there are things that can be done, and that kind of gets to also some practical advice about what are some of the measures you might be able to take or consider taking, not from a liability standpoint, but discussing it from the standpoint of the obligation to protect the information, which I think is helpful to lawyers. But anyway, that just kind of struck me, that the facts are such a fait accompli. It's kind of like just starting from the point where there's absolutely nothing that anybody can really do to take care of the situation now. And the only question is, you got to give notice to your client. Well, yeah, but the harder question, and maybe more helpful, is to make it a little more rigorous somehow. Maybe there are things, because it also leaves the question, what does the lawyer have to do? And that's the question from the law firms too. What do I have to do now? Yeah, I realize notice is a possibility, but what else do I have to? I have affirmative obligation to do what? What should I be kicking into play now to try and recover or protect this information? Some of that is, thinking ahead of time about the things that are available that you can do and being able to turn it into a stone and all of that. Just a thought. Yeah.
How does this differ materially from hacking and ransom stuff, cyber hacking and all that? I mean, at least with hacking, somebody's got it and it's using it, so there's kind of a higher sense of urgency, but it still gets down to the same thing. You asked, who do you notify? Insurance companies can tell you notified all your clients.
Well, that also raises a training issue. Law firms now have to train their staff to notice phishing emails and spear phishing emails. It's a whole now level of, and I've read a couple of footnotes, you might enjoy this, in researching an article I wrote for the Santa Barbara Lawyer. They actually watch people that go into firms that service the law firms. It could be a plant, a landscape company that waters the firm's clients. It could be a tech company, and they'll send an email from that company, purportedly from that company, saying, "I need your." The Chinese send their A-level hackers, according to one article I read, against the Pentagon and government agencies. Their B-level hackers, Sony, C-level hackers go after law firms. The entry level, I found that quite amusing. All right, so, but should I go in this direction, guys? Should we add this kind of preventive stuff? That really opens up the standard of care issues, which I thought the consensus was to not go into.
I think
turns it into a different kind of opinion. I don't know whether to go there.
I think to some extent I think it's a good idea. I don't remember whether we agreed or not agreed not to go in that direction. Perhaps we did. And I missed
Well,
it.
last year we did. I remember I raised it, and I was told that it was beyond the scope of what we were going to do. Because I thought there's a lot of opportunity to talk about preventive measures. I mean, maybe in the context of to leave it into the facts that you're talking about, where it's like, well, let's just not assume it's there's nothing you can do about it. Like, go back and look. Okay, go back. Can you change your password? Can you see what was any browsers that were open that you could, change those passwords? Is everything, was it actually downloaded on the laptop, or was it just accessible by a browser? And that's maybe a way to incorporate that. I think it's very helpful,
I
but.
don't think so much preventative, but certainly safeguarding once it's out there.
Yeah.
There's practical things like that you can talk about from my perspective without getting like a standard of care type of thing.
Right.
And it also plays into the duty of confidentiality, because to the extent that's saying that part of that is taking reasonable measures to safeguard information. I mean, they're really thinking about the type of information and how that may heighten what you do. But I mean, I think there's space to draw on practical points in that regard, and I don't think that puts us in the standard of care. So, of course, I was probably the one who told you that that's not.
No, you weren't.
But that would be the flip flop.
Okay, that's all right. That may be a better place to discuss it under confidentiality, because you have an affirmative duty to safeguard the information, so.
All right, anything else on 16002?
I just had some minor
Sure.
editorial things out.
Right, sure.
I guess I would say, when you were talking about the sort of more ambiguous situations, Drew, which I do think it would do more service to our readers if we tackle real, things that are close to real life scenarios. But I don't know that I'm sure the preventative stuff and going through what to think about preventatively would probably be helpful. I have no idea what those things are, but the other point that you made is sometimes there's situations where it's ambiguous whether or not the data has been accessed, and that seems to me like a really hard question. Like, at what point do you then significant development issue becomes much more murky, right? Do you tell your clients when it's possible that their data has been accessed? I mean, maybe that's too sticky for us to want to.
Well, arguably, that's the case with the flash drive in Attorney B's briefcase. You don't know it's been accessed. They might even not have
Okay, so
found it.
maybe. So what are we saying about that currently?
I only address it separately because I just treat it as as a device, an electronic, equivalent to the laptop. Maybe that's not appropriate.
Well, it seems, first of all, I did have a sort of question about why the briefcase isn't in here. Like, are we really doing much with that second scenario? And why do we as COFAX need to have this automatic desire to have two scenarios?
Yeah.
I don't know that we
We
need.
can certainly remove it.
Yeah,
we can take
but
Well,
on the other hand, if it provides an opportunity to talk about a question of where it's not clear, I mean, it's also not clear in the stolen laptop.
I was gonna say, how do you ever know? The only way you would know is if you had some browser where your password was pre-programmed into it, and you can tell because the firm can tell and track and say,
Right.
someone accessed this
Or-
information
or
at this time and it was after it was stolen.
A hack.
Yeah. But
Right.
otherwise, you're probably not gonna
You're
know.
always-
Yeah,
and-
if they,
So I guess the question there is, do you always just have, is your ethical obligation to assume if you've lost control of this information that's
That's what the
easily
insurance
accessible?
companies say.
yeah, I think you should tell your client that there's a possibility that
Yeah.
somebody is able to access it, although you're not sure.
Right, okay, so maybe, but I think that's probably, I think a lawyer might ask that question, so I think we should tell
Yeah,
them.
there's some interesting academic writing on this, Lord's Word, that has taken the view that just the possibility that someone may have accessed it is not enough. Analyzing ABA 1.4, there's a piece by Eli Wald, a long article, probably the longest piece about this.
Yeah, his name again?
Eli Wald, who teaches at the University of Denver, that takes the view that that there's a difference between situations where there's a possible compromise and you don't even know whether it's happened and what to say exactly. And
What does he conclude? You have to know that it's been accessed?
that, as I recall, that's the dividing line that he puts out.
I mean, yeah.
I'm not suggesting I'm not suggesting that's the right analysis. I'm just suggesting that there are people who've recognized the continuum that Amy's been talking about.
Sure.
And that
What is he balancing? What interest is he balancing when he says?
among other things, being alarmist. And
Unnecessary fear of the client.
yeah, well, that was one of the, as I recall, that was one of the ones. I don't
Well,
recall.
it's not
I hate to
unreasonable.
say it, but most of the rules we're interpreting are designed to protect the client.
Exactly.
Yeah.
Right.
So,
Well, but
I'm
no-
just curious what.
Yeah.
So, I mean, just so I can say, I mean, I agree. Similar conversation we had on the prior opinion. It depends specifically what is in the briefcase or what is accessible on the laptop or the thumb drive, and it may change one's analysis. But regardless of the fact pattern, if I had a briefcase with a client confidential information in it, whether I stepped off the BART train and left it under my seat or just on the floor, whether someone broke into my car in front of my apartment in San Francisco and took my bag out, whether I went through TSA and someone went off with my bag. For me, I have a hard time. It's almost like the lawyer, to take the position you don't have to tell the client that this has occurred. It's more of a mental gymnastic exercise than just to say there's significant development. There might be personal information with a social security number, address, confidential information regarding the client's case. And of course, I don't know if someone's going to access it, might use it to the harm or detriment of my client. But this event has occurred. I got to tell the client. And I don't know the Eli Wald article, but I would, for me personally, I'm struggling and would want a more persuasive argument, for me personally, to explain to me why I wouldn't have the obligation to tell the client under either of those three hypotheticals that I provided that that event didn't occur. And it may not result in harm to the client, but this is something the client should be made aware of. They may have to make changes to their personal information or whatever the situation may be, and again, may change depending on what the information is that's in the bag that has since been gone or left behind or taken. But the fact that you don't have to alert the client, or there may be a situation which you don't have to alert the client unless it was totally unimportant information, I have a hard time being persuaded by that.
I mean, if all you lost were some pleadings that were probably filed before,
Right.
discovery responses that didn't have any real confidential information in them,
Right.
then it would be all right. But otherwise, yeah, and it might be something, the client might have to do something as simple as just monitor the credit report to make sure there's no weird activity. It might not be much, but it might be enough. It triggers what Eric was talking about, the damages issue, but that's kind of tangential, or it's, the issue is more, the information, how they did, what it could do.
What if there was a temporary loss of control over the data What if there was a temporary loss of control over the data and the law firm took steps to believe that the data was not secure?
I would have to be told.
Still told.
What did
Temporary.
DLA do last year when they had their servers shut down?
What's that?
I said, what did DLA Piper do last year when their servers were all shut down and they had to put placards in the lobby? Probably had to tell. You guys didn't hear about this?
No, what is it? What happened?
Wasn't it DLA Piper?
Yeah, it was.
They were hit by ransomware, was it? And
Yeah.
their entire system shut
And
down.
who's the they again?
DLA Piper.
God.
And right, complete shutdown of everything. The associates and folks showed up to work in the morning.
What did they think happened? What was it?
It was
Just
ransomware attack.
Ransomware.
Well, so we talked earlier about what Steve said, you could turn your computer into a rock.
Yeah.
So, you lose your laptop, an hour later you realize, you call your IT, you say.
Shut it down.
Yeah.
Replay.
Right, and so there was an hour. You have an encrypted laptop, first of all. It's pretty unlikely that anything happened. maybe you can run some tests, I don't know. Does this committee think you could ever get comfortable? I, for one, do, that, you know, if you had taken a lot of precautions to be able to do what you were able to do, and you did those things, I think that it's a very, you know, very small possibility that someone would manage to access client data. At that point, do you still have an ethical obligation to tell the client what happened?
Because of that 1 hour window, perhaps? But the laptop was encrypted?
Let's say that for this hypo.
No, the risk is so small.
Okay.
Yeah, I
You
don't
have to be pretty confident.
If you have nothing on your hard drive of your laptop, then everything you use is by browsers, and your laptop gets stolen, and it's encrypted, but you could also change all your passwords to your, I mean, I don't see how that would be a really realistic risk that someone would be accessing that information. You could just, like, you know, immediately shut it down or call your IT people that they could shut it down.
It's like you leave a briefcase in the restaurant for 2 hours.
Right.
And
Come back
forget
and
it,
sit
go
there.
back, it's there, you
Yeah.
don't know who accessed it. So do you need to tell all your clients I left my briefcase in the restaurant?
Well, that's,
Another example.
I'm interested in the answers.
The
gray area.
Ransomware is different for the reason, potentially for the reason someone pointed out, which is, I mean, in that scenario, the manner in which you lost control is indicative of someone trying to utilize that information or capitalize on it. Leaving it in the restaurant or on the, you know, bus, and you're able to go back, or depart, and you go back an hour later, 10 minutes later, you realize you get on the train going the other way, you go back, someone turned in your briefcase. You don't have, the way you lost control of the information was not indicative of someone trying to access it, it was just a loss of control.
So why don't we change the second scenario to be she goes back and retrieves the brief. She remembers it was a restaurant, a bar, whatever, and we create that ambiguity. So it's been out of her possession for X hours, and then we'll discuss the nuance of that. I don't know what the answer's going to be, but what do you think? I mean, does that add to the opinion to make it a little more realistic? Because that is a realistic scenario. I mean, people misplace stuff and they retrieve it.
It's testing your expectation that confidential information has been released.
Right, it's a
That's,
judgment call.
you're setting
Yeah.
standards for that.
Yeah, you're kind of,
I will say, in the real world, I've seen that a bunch of, the lawyers think they have regained control of the information. It was a temporary exposure or loss. It wasn't directed to someone, there was no indication that it was something someone was trying to do to make them lose it. It was their error or what have you. And the question becomes, do I really now have to go tell, 100 clients that, for a brief period of time, even though there's no indication anyone actually accessed it, and we've taken, remedial efforts, and we have good reason to believe it's all under control and protected, now we have to go back and tell them there's this outside chance that, someone may have looked at this stuff for the hour and a half or whatever.
You have no reason to believe it's going to cause them any harm. It's like you wrote a motion and you missed the big issue in the case, and then the day before the hearing you think of it and you save the case. Do you have to tell the client, my brief wasn't very good, but I saved it in order?
I mean, so what's the position? Our position is, unless you are confident nothing has been accessed, you don't have to tell. But if there's any question, then out of an abundance of caution, you should advise the client that it may have been compromised.
would it be objective test, you mean, a reasonable lawyer?
I mean, what do we,
What do you think, a reasonable lawyer would conclude? Or you think subjectively, do you?
I don't know. Yeah.
But just as a small point regarding encryption, the Department of Health and Human Services regarding HIPAA regulations and the security rules that affect physicians and psychologists, they specifically note that if protected health information is encrypted by their standards, that is a sufficient threshold by which a notice to a patient is not required. So if that's of any use to you, encryption meets that threshold, at least for that agency in those circumstances.
Gives you a reasonable basis to not
Yeah,
clear.
they call, their terminology is a low probability risk or something very close to that. So at this point, providers in my field would be really stupid and uneducated to not know that by now. Mental health people almost instinctively should have anything encrypted if they're using electronic devices.
Yeah,
for
unless they
patient
gave hard
information.
copies to their attorneys, which were then given to PDF.
Yeah.
Or their attorneys printed them out, right?
Which, by the way, is one reason I don't keep any patient records in any electronic form. I couldn't sleep at night with
I
them.
guess we have to ultimately answer this question about whether we want to address this issue, but well, no, but I mean, if you did, one of the things that it allows you to do, which could be helpful in an opinion like this, is if we had, I'm just making this up, but let's say we addressed it and we basically said, unless there's some kind of really, whatever the standard is, strong basis to be confident, and make this up, we don't have the language, but some really good, strong basis to be confident that the information is not actually, it may have been temporarily compromised in the sense it was accessible or something, but hasn't actually been accessed or used, you're going to have to do these things, providing notice, etc. It allows you to bring into the opinion some of these things we talked about that maybe helpful anyway. What are the types of things you could do in advance? And then make some of these things like encryption, they may affect how you answer this question downstream. So it's not saying you have a duty to do all this necessarily. You don't have to encrypt everything, but it gets people thinking about it. And what you do in advance with foresight could affect how you're answering the downstream ethical question of, what's my obligation in this scenario? And maybe it is different depending on what you put in place at the beginning. If you can turn it into a rock, if you can.
Yeah, but we can use those encryption, turn it into a
Anyway, no, I
in
know.
connection with the stolen laptop.
Yeah, no, I'm just saying it also folds into it seems to me it folds into this answer because it's kind of a preventative measure that could make the answer different. The answer could be along the lines of what Steve was saying. If the answer is, well, if it's encrypted, that gives you a reasonable basis to think it wasn't able to be accessed, then it's giving you a reason to be thinking about going to the front. Anyway.
All right, I think I'll play with the second scenario and create this ambiguity. I think it's more interesting. I don't know how it's going to come out. Let me try and write something. If it writes easily, maybe. If not, we'll come back and revisit it. How's that?
Okay.
Be more realistic. I like it.
All right. Why don't we take our
Together, stretch break.
3:15 stretch break?
Anybody else
want to change
hold?
the faxing.
Can we turn the?
Oh my God.
Thanks,
I
Reggie.
just can't believe it. You're
No,
right.
Whoa.
And so like a herd of lemmings, about 5,000 kids moved about 200 yards.
Yeah, but
All right,
And I was in that group.
let's go back on the record.
the other ones would be on this side.
We have one more opinion to cover this afternoon. Before we get to that opinion, we want to talk briefly about the symposium that's coming up. April 6th, there's a copy of the brochure that everyone probably received today at the meeting. Just a reminder and a request, if you haven't already, make sure to take a look at it, in particular your panel. If you have any edits or changes, make sure to get them to Mimi. This is going out to print or out for mass distribution at the beginning of the week, so she needs to know by Monday. So give it one final, pass over, and if you have any comments or edits, make sure you provide those to Mimi. I would also just make a pitch. I've done it before, but we should do everything we can to try and get as many people as we can come to the symposium. So please do what you can to make people aware of the symposium. Andrew may add a little bit to this, but just so you know, we now have all of our panels composed. The people who are moderating have their panelists, and we really have some outstanding people on these panels, and I think they're going to be great. And so I really encourage you guys to create whatever interest you can. And if you know people that might appreciate these types of issues, please make them aware of the symposium. We have a lot of people that come on a regular basis, but it'd be great to see some new faces, even maybe some younger lawyers that are working with other people in this area of practice. We have some of our regular attendees are actually going to be panelists, so only more reason to get other people for our audience that are not just prior participants or attendees at the symposium. So, anything you want to add to that, Andrew?
Yeah, just a couple housekeeping items. As Drew said, I do want to thank all the moderators. You guys worked really hard to identify your panelists and get your panel descriptions in. The symposium on paper looks great, and I know it'll be great in person. I just want to reiterate what Drew had to say. Please, if you're able to, take the time to ask associates and partners in your firm, colleagues you practice with, people you know at local county bar associations, anyone through law school connections. Just alert them about the event and encourage them to come. It will be on a Friday. It was on a Friday last year as well. It's on a Friday this year at the State Bar Building in San Francisco. It will also be available via webcast. So as we have great exposure to now, you will also, those of you participating will also be subject to the video camera. So we're looking forward to the symposium. That'll be our next meeting. So a lot of work to do between now and then for the moderators, and State Bar staff will be in communication with you guys in terms of the deadline for your materials and what have you.
I would just comment on that quickly. I think based on the schedule they gave us, it was March 16th, so I just throw that out there. It's fast approaching.
Right.
Do we figure out where we're having the meetings already?
Things at the State Bar Building.
What do you mean by the 16th of March?
Well, you tell me, I'm just looking off the tentative schedule that had previously been distributed.
Right.
March 16th was the deadline. What is the coming deadline for moderators to submit the written materials? So the panels are supposed to be submitting the written materials that'll go with their program by the 16th, which is not very far away.
Correct. So Mimi and Lauren will probably be in touch with you guys via email maybe next week, just to describe the format. The material's usually available via the internet. We don't print it out and mail it anymore. But yeah, the 16th is the anticipated deadline as of right now.
Andrew, are we also having a regular meeting on Saturday?
Yes.
Do we know for sure where that's going to be yet, or is that still?
It's, should be at the State Bar building. I don't know the room we're in yet.
So we don't need to use it. At one point, we were talking about using it on Carnival.
Correct. Yeah, we should be at the State Bar building. It might be tight, depending on the room that's available, but we'll be at the State Bar building. We anticipate being at the State Bar building. One other housekeeping item is with respect to the self-study MCLE articles. Due to the transition of the State Bar over the first of the year, Cal Bar Journal was not published in January, and so all your deadlines have been pushed by a month. So, and there is some people get confused at the way the list is organized, so I'm going to use Amy as an example. She was responsible for the March issue, and you'll see in parens her deadline is February 1st. And so please follow the deadline for when to submit your material, but per this notice, add a month. So although you may be responsible for the March issue, the idea is to get it on February 1st, so it can be formatted and ready to go by the middle of February, and it can be posted on March 1st for the March Cal Bar Journal. But again, just push yourself down. So if you're due,
Could the agenda be updated for next month?
Absolutely.
So if you were due February 1, you're now due March 1, is what you're saying?
Good idea. Everyone's a month later.
Yes.
Later,
So Marshall, you were due in December, you're now due in January. We'll see you next
I know,
year.
it's so true.
You already did yours?
I'm the last one.
Everyone gets pushed 1 month. So Drew was fast approaching and was concerned. He's responsible for the April issue, had to get on March 1st. Now he gets to wait until Easter and submit it on April 1st.
This is just a
Anything else
question
on the
to ask
symposium?
if they would submit the two that we have pending right now for the February issue, for the March issue. To just see, because nothing got posted in February. So Steve's
Nobody posted this article.
So Steve's
Right.
article should have been posted for February, and Suzanne's will go for March, but Steve's didn't get posted as far as I know.
Right, I'll have to check
So
with
check
the
and-
staff who
We thought
manages.
we'd give them a twofer.
Oh,
Yeah,
yeah, do a twofer, that would be great.
I think, I'm not opposed. It's all digital, electronic. I don't know what their concerns may be over there, so I can't answer that question.
Let us know, though.
Is there a
Because
list?
conceivably, it could, it's 2 months ahead instead of 1, right?
It
If we
could,
said we're not
but I don't want to
gonna
give
do-
you guys too much leeway. But
Well,
no.
but as the person who's up next,
I agree, it should, but for now, let's just move it 1 month and we'll see. I
No, I'm
agree.
just saying, but.
Is there a
everybody
list?
knows.
There is in the
Assignments.
agenda.
It's at the end of the.
Oh, okay.
And it's also in the assignment document we send you guys every month.
Where are you?
You're now due June 1st, Ken.
Yeah,
Okay.
you're on the July issue.
Okay, got it.
Okay, just two other items. This the first of my two items is for first-year members. I don't know if Justin's on the phone.
Yeah, I'm here.
Oh, hey, good. Glad you haven't fallen asleep. But for all first-year members, just a friendly reminder, we've all attended enough meetings now that hopefully you all have gotten a sense of the opinions we're working on. Please submit any requests to myself and Mimi for a drafting team you might be interested in being a part of. This is the last request. I'm not saying it'll happen at the next meeting, but shortly thereafter, if you don't volunteer, staff reserves and will exercise their right to assign you to a drafting team. Also, be aware of opinions that have a lot of people on them, a lot of members on the drafting team, try to avoid that. There are a handful of opinions which only have 2 or 3 members on the drafting team, and those are the ones that could definitely use some shoring up of support. And then lastly, without being too annoying, but with respect to the opinions, this meeting has been great because we've gotten a lot of detailed discussion on the handful of opinions that were submitted, but I would strongly encourage, it would be great to see a full agenda with opinions submitted for each item on the agenda. And I don't think that's impossible or unreasonable to obtain. So I just strongly encourage you guys to get an opinion in, to be considered of every opinion we're working on. And it's not just the responsibility of the lead drafter, it really is the drafting team. So if you're on a drafting team and your lead drafter has not been able to submit their opinion, take the initiative to let them know, schedule a conference call. State Bar staff can help arrange the conference call. Circulate an email. There are other tools and strategies that can be implemented to get an opinion moving. Members of a drafting team can take on a certain section, so the lead drafter doesn't take on the whole thing. There are a variety of approaches that can be undertaken, to keep these things moving. One concern, as we all can observe from our own experience, there's sometimes a lack of momentum when opinions don't keep coming back, and those that do come back maintain that momentum, and we get closer and closer to publication. So just one additional pitch from staff to request that everybody submit an opinion for next meeting, and I'm done talking, and we can go to our next opinion.
This is Eric's opinion, right? The last one.
I think it's Steve's.
Oh.
Steve took over his least favorable opinion.
From Michelle.
Oh.
Yeah.
Oh, sorry.
the last one we have on
Okay,
Another
great. I
another
had-
another staff exercise of rights in which I asked Steve to take this on again here, and he was gracious enough
Which
to do
opinion
so.
number?
13002. No, sorry.
Sorry.
Yeah.
Yep, 13002.
Right.
That's my first item.
Okay. Well,
I really am gonna change
yeah, let me see if I can find
it.
my
Find your number, competitor.
notes about this. Okay, 13002. What have I done? All right, here's what's happened. Here's what's happened. This is, actually, I did this for a couple of meetings.
Correct.
ago,
We didn't get to it.
And we didn't get to it. One, I keep trying to minimize, this was written originally by somebody unknown to me well before Michelle, who liked kind of purple prose. So I've been continuing to work on taking out all the editorializing that I can. And then I went through, in line with the comments, and I think I presented this 2 or 3 meetings ago, I took out a lot of stuff. And I took out everything that I thought was covered by our 1989 112 opinion, because why bother? And I took out everything that I thought was likely to be mooted by 1.14 when it's adopted, because why write an opinion that is different in any way than that? I also backed off. I mean, I think a lot of what we were doing wasn't really warranted by the facts, because we don't really know. On these facts, the attorney does not have the kind of knowledge of impairment of the client that would trigger even the kind of rights and obligations that are created by 1.14. And so we were writing an opinion that was sort of not based on the facts. And I left out the stuff about capacity to make a will, because I think it's basically irrelevant to the question that we're interested in. And it actually, it really boils down to the question of what this lawyer's obligation is in terms of continuing, or you can call them continuing, or even if the relationship doesn't exist with the client anymore, there could be obligations that survive the end of the attorney-client relationship. Duties of in effect, defend what the lawyer did for the client, right? Or not to ruin what the lawyer did for the client, right? And also to honor the obligation of confidentiality to the client. And the question, and the duty to release files is kind of derivative of the duty of confidentiality, fundamentally the question of what your duty is in that situation. And then the question becomes, and this is why I wondered whether it really, we're talking, the question I've written about is the question of how to think about, I think it's note 3 in one of our earlier opinions that basically says, you gotta have confirmation from the client. And that seems to me probably right for all these things. You need confirmation from the client that the attorney-client relationship has ended, that you can take a step that might be detrimental to what you did for the client, might actually set back what you did for the client, and that you can release the files to someone who is otherwise a stranger to the relationship in circumstances where there may be damage. And so that's okay, so fair enough. So more is required than the lawyer calling up and saying, I represent your client. And if you've got a file release signed by the client and you doubt that it's authentic, more is required than that. And then the question becomes, what more do we want to say? Right? What more do we want to say? Do we want to say how much more? Do we want to spell out what you're supposed to do? Do we want to opine on whether you can go back to the niece, right, and tell her what's going on? Right? Is that consistent with your duty, your continuing duties to your client, or not? A little bit mysterious to me. I mean, I'm sort of just trying to follow because I haven't ever seen what the sort of intrinsic force of this opinion was to me. But following it through, that's where I am. Right? And I open it up. I'm still completely open to the view that this opinion isn't one that should be written. I'm open to the view that I've got what I've tried to do wrong, and I'm open to the view that any view of any kind with respect to whether we should go further and what we should do.
So before we get there, I should have made this announcement, and again, a caveat about breaking momentum. I'm going against my own advice. I should have made this last announcement during my staff report. We're passing around a binder of this year's applicants. Just feel free to flip through it as we're discussing this last opinion. And if you know any of the applicants or would recommend them or have any comments about them, send them to Mimi and myself, and we will get those comments to the nominations subcommittee that will help inform them when they consider this next year's applicants. But excuse my interruption, and let's get back to Steve's good question.
I'll try to overcome Andrew's interruption of momentum.
Thank you.
First of all, I actually think that what you've done here is really interesting, Steve. And this is the rare occasion when I find it much easier to look at the clean version than the red line version.
Yes.
Because you've taken this long and tortured opinion and basically reduced it to 3 pages. And on that, for that novelty alone, I'm kind of inclined to vote it out into final. But I also, take seriously the questions that you pose. I think you've actually answered the question posed in the basic premise of this opinion. And I'm a little leery to go down any one of the 3 roads that you've listed as potential additional directions, because I think that's how we tied ourselves into a 5-year knot now? Of the 3, if we're going to do anything, I like number 2, I think it's number 2, what if you can't establish some contact with the former client? But I think that if we could start going down the slope of what's sufficient contract, or what's good enough contact, we're going to be tying ourselves in the same knot as where we've been for the last several years. So standing in and of itself, by itself, I think your 3-page opinion actually answers the question. And the only one that I'm tempted to go down personally is, so what what do you do if you can't get contact? Because that's the real thing for the practitioner.
Well, I would broaden, I mean, you said contact, but it's really verification.
Yeah, it's very.
Right.
And that's why you have to have the 3 questions. I see what you're saying. I've watched this enough to see these things spinning off in all kinds of directions, but you're looking for verification. And if you can't get verification, there has to be an answer. What do you do?
Well, one direction, completely outside the usual ethics arena, is the Elder Abuse and Dependent Care Act, where you have suspected financial elder abuse. Normally, attorneys can't do anything. You can't report. You're not a mandatory reporter under the statute. And certainly 606(8)(e) prevents us from revealing any information. But this fact pattern might lend itself at least to giving a solution in that direction, though it may be dangerous, and so I hedge it. But here we have information that the attorney obtained from a completely outside source. A signature line with shaky signature, and communication from an attorney claiming to represent. And a directive not to communicate at all with his own client or her own client. In this specific narrow fact situation, it might be okay for the attorney to report suspected financial elder abuse to the DA and let the DA investigate it if the attorney is not able to get a hold of the client at all. But that's just because of the way we've written these facts. That might be a solution here. Because otherwise, I mean, you cannot reveal that the client believes that, that the stepson is pastoring her for money, or that, any of the information, the testamentary intent. You cannot reveal any of this, but you can forward this to perhaps. Anyway, that's my thought. Now where? Maybe here.
I ask a question that may be a stupid question, I should know the answer to, but you commented a couple times in here, you put the question, verified versus direct.
Right.
What exactly is the distinction conceptually? What would verified mean? Or maybe that's part of your question, but I mean, I'm trying to understand.
I'm not sure. I think what I had in mind is one thing is speaking to the client. Okay,
That would be direct.
What?
That would be direct.
That was what I think I was thinking.
Because verified suggests a third party is.
Verified suggests you could rely on something other than direct communication with the client, or whatever it is.
So maybe that kind of gets to your first question, is like, could you just get something better from that same lawyer who you sort of don't trust at the moment? That might be verification.
I think that's pretty much what I had in mind. And not that I thought it through as clearly as this discussion.
I mean, when I saw the questions about direct or verified, myself, I thought you need to sort of get beyond this. You have this person who you have reason to potentially not trust or be able to accept what they're telling you. Right. You need to go beyond that. The logical step would be the client, of course. Right. And I don't know, I didn't know if an issue was being raised about, well, does the client somehow have to be, verify their ability to give you, I would think normally if you could contact the client, whether that's by phone or what have you, if you're able to actually have a discussion with the client says, this is what I want done, yeah, I hired this person, or yes, you have the authority to transfer my file.
But then if you have diminished capacity, you're going to have to then address that. If we go down that road, he does establish contact with the client, then I think we definitely have to address the diminished capacity problem. problem, and then maybe it's a thorny issue, but you can maybe go to the probate court and get some direction on when you have capacity to consent. But I don't know, and I don't practice in this area, so anyone who does should probably.
I think coming back, though, I think the language in the footnote, which I don't want to give too much weight to a footnote, but the footnote of in a 1994 opinion is confirming with the client directly. Right? That seems like the answer would be. So the answer would be you have to. That would suggest got to speak to the client. Right. And then what happens? Then I think which follows is the question: what happens if the client is past the point of being able to think about these kinds of issues even, and talk intelligently about them, right? I don't know what the answer there is. Do you then ask the court to decide? What's your,
Yeah, and
that's very
how
hard.
are you going to do
Seems
that?
like a
Or-
significant shift if you go down that
Yeah.
road, because we're going from the primary issue here has been sort of an obstacle to your having direct communication with the client, getting ask all this information, or given direction by this sort of third party, the new lawyer. Right. You have some sort of tangential information to suggest that your client may be taking advantage of something, or being taken advantage of, and we're saying, to what extent you have to really just automatically do whatever this lawyer is telling you. Now it's a totally different question, and once you get beyond that, he's out of the way, or she's out of the way. Now what's your obligation to second guess the direction of your client, right?
Well, you're not really
Your client is saying,
second
this is what I want you to hand over the file. But now we're talking about, well, but if my client's of diminished capacity, do I now have the second stage of, to what extent can I rely on what my client tells me?
But then those facts have to be stripped
informed-
out of there or
Informed
something.
consent.
Yeah, I mean, you have to.
This is very similar to the situation when, you're being subpoenaed to turn over a client file or a former client's file, and you do not have the ability to waive that privilege, so it's the client itself that has to waive it. So you have to get informed consent from the client to turn over that confidential information. And I have been in this situation, and my clients have been in this situation, where if you feel like your former client was not, has not been given all the details, has not been properly informed to make, if all these issues have not been properly disclosed to them to make an informed decision, then you refuse. And if you have to go to the court and the court has to make a ruling on it, then so be it. But I think that if you're not satisfied that the client is knowingly consenting to it, then you can't turn it over. Because that is the utmost important in protecting those confidential communications.
And
Yeah,
now I'm starting to see where sorry, go ahead.
That's okay. I think the problem, you were obviously trying to work with various iterations of different opinions, where I think we went down this road with some of the stuff with the competency issue, but I think the facts are so aligned to this issue of, like, I have this elderly vulnerable client who I'm suspecting maybe is incapacitated, or at least is susceptible to abuse, but then the opinion or the discussion analysis really addresses this issue of, like, verifying a client, like file transfer issue. So I feel like we can't have that fact pattern and not address this question of, like, when you do get the authorization, like, well, what if she's like, yeah, go ahead, honey, and do that, and I think if we're going to have a file transfer, the obligation to verify in any context where you got a piece of paper that said, I'm the new attorney and don't talk to my client, you would want to verify that and make sure that you talked to your client and found out. So I kind of feel like we can't have that fact pattern without addressing some aspects of the fact that this client, you have these suspicions about their capacity or their ability to give informed consent or something in a meaningful way, and just leave it as because otherwise we should just strip away those facts and say, like, we're just talking about the attorney's obligation to verify.
In which case we don't really, maybe we don't need it.
I think the facts do lend themselves exactly to this elder abuse, diminished capacity. You've got the niece shortly before, just, you know, the niece didn't reach out. The lawyer ran into the niece and said, how's she doing? And the niece said, well, you know, mine's gone.
Did what?
So that her mental capacity is diminished, that she's not what she used to be. And so I think in this situation, it does lead to that problem where if the lawyer does get a hold of the client, then the lawyer needs to gauge whether that consent is given knowingly and whether that consent is given through undue influence or some coercion of some kind or any of these things. And so it, you know, we can talk to many trust and estates lawyers who have to deal with this problem.
Yeah, it's
Another angle.
Go ahead. I have this very case going on right now, and the type of incapacity has allowed a person to be unduly influenced. So they can, for a short while, appear perceptive, appear cognitive of the issues around them, but they're not in the long view, and they've been taken over by somebody else. So my client gets fired, and the new firm takes them on. New firm has the temerity to videotape this woman when she changes her estate dramatically that had been in place for basically 40 years. And if you read the tape, it's a series of leading questions that only require the woman to say yes or no, yes or no. The point of it is, my client did not call up his client and say, am I fired? He just assumed he was. So they didn't follow what you're recommending. Had he, she would have said yes. But she didn't know what she was really doing. That's the problem.
Another
The
angle
signature
here
on
is,
that paper is like a yes.
another angle is following up on the contact with the niece. I can see that going in a couple of different directions. If we opine that attorney can go a little bit deeper, not just I need to reach your aunt, but the circumstances under which why I need to know. The niece could say, oh my God, that's awful. We got to do something about that. Or, oh yeah, I know, stepson has changed. He went through a 12-step. He's great. He shows up. He really loves her. She's going to change her plan. I'm all with it. Everything's fine. So I can see where that may be sufficient verification. Maybe. I mean, it may not have to necessarily be direct. On the other hand, we're going deeper and we may risk disclosing confidential information. But that's part of why the facts to me suggest that would be okay to ask the niece that kind of question. So I would, like your third question, I'm suggesting that we explore that a bit to allow for that possibility, because I think an estate lawyer and attorney's situation would feel mighty compelled to under these kind of facts, limited to these kind of facts, where it's so ambiguous, to risk disclosing confidential information for the ultimately what she hopes is the best interest of the client. So, I don't know.
I'm going to express an anxiety here.
Yeah.
I am really anxious about the incapacity issue. And it's in part because I genuinely don't think I understand it very well. Right? And it's a little bit like what we were talking about with the whole question of lawyer impairment earlier. There's a lot of, but I'm also aware, and I cut this out of the opinion because I couldn't figure out. But there's a tension here because I think we all have this idea that to change your lawyer or to waive confidentiality or to do stuff like that, you have to be competent. But the rules about when you can change your estate are, not remotely like that, right? And so there's this funny kind of tension that I don't know exactly how to resolve between the client's freedom to do something that's essentially what Marshall was describing, sort of not really understand what they're doing at all. And our sense, which I think, Kendra, you described really well, right? That if you're going to fire your lawyer and instruct your lawyer to reduce, you need something that's very different. I'm not quite sure. So there's a competence question for me. What is, and then there's a question of which standard should govern, which way of thinking about it should govern. And I don't have answers to both those questions, but I'm also, because I can't even really frame how to think about them, I'm anxious about answering.
Isn't that issue in part something that we spent a lot of time on with RC and 114? I mean, my understanding is that whole business about getting the consent of the client at a certain point was a product of like input from people that talked about this kind of stuff, like the probate code and what you could do, even assumptions that even though you were impaired, certain basic fundamental things could be done. And they make some reference to that, but
and there's a very clear.
They struggled with that.
Yeah, and that's in a kind of the framework that 1.14 uses involves such a high level of confidence with respect to that issue, right? Maybe the right answer is that I think you're making a good point. Maybe it is that the answer, right? And I'd have to think about how this works. We'd all have to think about it together. Is that if you have that conversation with the client, right, and you become persuaded that it's a 1.14 problem, right? Then 1.14 kicks in. But I wonder if there isn't also a kind of intermediate area, right, where you're not so clear that the client is impaired in that way. But I'm not sure. But maybe 1.4 is the answer. Is where we pipe the opinion back into 1.14 at that point. That might be the answer.
I mean, I do hear people sort of suggesting that at least the way it's framed now, it seems like people are saying it would be important to cover the back end issue in some fashion of what, I mean, to your question, Mark's as well. I mean, it's direct confirmation. What does that mean, or what does that potentially mean? I mean, am I getting that wrong? It sounds to me like a bunch of people are saying, well, the way this is framed, we have to answer our questions. Assuming it's going to be an opinion and so forth, we have to say something about it at the end of the day.
Well, if I were faced with this situation today and don't have a clear answer, and you're in probate court, you can't always consider petitioning the court for instructions if you have an open mistake. If you don't, you can always file a separate action before the judgment decide. But that's risky. Yeah. But you can always get instructions in that environment.
Well, I mean, maybe maybe we say something about it, but we may be confined in how precise we can be, and it's more of, you have to get direct confirmation, sort of making this up at the minimum. I mean, that sort of implies talking to the client. And then you have to be, in talking to the client, we don't know under these facts it's going to be the case. Is this a significantly impaired woman? Was she really being taken advantage of? Is she going to say, yes, that is my new lawyer, I tried to get him to get the file? Does she maybe have reasons she does want to have the nephew, get more under the plan, whatever? We don't know what's going to happen there, but maybe we can talk about the type, then, yeah, you got to have direct communication with the client, and then, that communication has to satisfy you, that you're getting, I don't know the right way to say it, but, the informed direction of the client, or whatever the language is, and make the point that, it's possible if the lawyer thinks in actually getting to talk to the client that there, is a significant issue about impairment, then these types of things may need to be considered, or avenues where maybe you could go get direction or something. I don't know. But it sounds like people don't want to leave it and say nothing about it. I mean, if it's going to stay in an opinion, it sounds like people are saying we gotta say something about it at the end of the day, which may be true. And I don't know, maybe it backs into 1.14.
I'm not sure. I think it runs in kind of in parallel. 1.114 suggests you have an attorney-client relationship, right? And then you're taking steps within the framework of a known attorney-client relationship. So there's a whole idea that you can't take actions in the client's best interest within an attorney-client relationship, right? Without the client's informed consent, right? And so that it's not, and then the point of it, you can take steps to figure out and kind of improve the likelihood of informed consent. Right? So maybe the answer is a kind of parallel kind of thing, which is, if, you've got to get the client's informed consent, right? And as with any impaired client, or you could, it says here you can seek the assistance of appropriate people, right? Which might be a way of involving Denise, right? And it's all happening not under 1.14 or them, but by analogy to that structure. Something like that might be a way to go. Because then that would keep your structure, Kendra, which is, we need informed consent to do this, right? But we actually have a framework for thinking about informed consent, even informed consent in the sense of firing the lawyer, waiving confidentiality, et cetera, and we could try to build on this structure.
Well, I think there's case law out there too, right, that addresses waiver and how the consent has to be informed, and that all the necessary facts have to be disclosed in order for that consent to be informed. I can't put my finger on the case law right now, but I think there is case law out there.
That would be a great, I think
Knowing
that's
an intentional relinquishment of your
Right. So the competency of the client would come into that if you didn't think it was knowingly an informed decision, So I think.
No, I'm with you. I'm completely with you. I mean, I think that could provide one kind of lever would be your duty to help the client make, to augment the client's resources to make an effective decision. And the other would be this notion that there's a structural or, a required content piece, which is interesting.
Well, and you have the obligation to
in most
protect
instances,
your privilege, absent,
right.
In
most
instances, comment 5 to the confidentiality rule 3.100 says that whether a member chooses to reveal confidential information as permitted is a matter for the individual member to decide based on all the facts and circumstances. So, I mean, you cite to this plus the case law that talks about waiver, and I think we don't want to make it too difficult. It's pretty much the same scenario, and if competence is something that goes into your facts and circumstances as to whether that waiver is has been informed and is knowingly done by the client, if you're not confident that it is, then you refuse, and then they take it to the court if
you
necessary.
request instruction in effect.
Right.
At some point, you might have, if you can't make it happen to your satisfaction with augmented decision making, like with Denise involved, you request instruction.
Right.
Right. And I think something like that. Okay.
File an action?
No, the other attorney.
I think you say to the other side, look, you want to.
I'm not going to give it to you if you want it.
Yeah, I have in mind also, when we talked about this at an earlier meeting, probably before I was even involved, when Michelle was still in opinion, we had a very interesting conversation in which Suzanne said, "Oh, this happens pretty often, not in the competency setting."
Right.
She said it happens pretty often, and people refuse to turn, and she told some a boy toy case she described, I think, the one she described. And she said, well, all you do is you call State Bar. They turn the file over right away. So what we're trying to do is also to inform that conversation, so that when you get the call from the State Bar in this situation, you don't say, look, I'm actually trying here to honor my obligation to the first client, right? And here are the reasons that I haven't turned it over, and I'm perfectly happy to, you know, if you can satisfy me that it's okay. I mean, it changes the leverage in that situation too. It
Right.
says,
Very smart.
Right.
what?
Pretty smart.
Right, and the courts see it that way as well. I mean, you are upholding your ethical obligations to the client, and you're keeping the client's best interest in mind. You're not
But
gonna
we
be
also
punished
don't
for
want
that.
to stop we also don't want to kind of freeze the situation forever.
Suzanne is the same person who said, I'm afraid about doing an opinion that gives people a reason to hold on to the file.
Right, exactly. Yeah.
Also the interplay with confidentiality and what you will be saying to these people that call you from the State Bar or whomever related to the client confidences. There's
Right.
obviously that tension.
Right.
Well, I like the idea of the waiver law. I think is something interesting to look at. There's something in the background nagging me, not nagging me, but I mean, I think it's relevant, but there may be a distinguishing aspect of it. I can't finger on it quite yet, but we're going to have to look at the context of those decisions and who's doing what on behalf of whom, where the waiver question is being presented. Because
I agree.
It's
I
not
want to think.
totally apples and apples. I don't know. I have this feeling there's.
I want to look at them, because I do think that there's a problem that they might not be apt.
But it's a
right?
good.
It's a
really
very helpful
good-
analogy.
Yeah, I'll look, I've done some motions on it, so I'll
Yeah.
look up, see if I can find that case.
I'd love to see some of the cases. That would be great. That would be very helpful.
It's helpful just though to sort of ask, like, what is, like, this opinion has this particularly odd genesis where it started as one thing and it's kind of stayed alive but changed a lot. And I mean, I think it would be good for us to have a consensus as a committee, so Steve doesn't just keep drafting, to say like, what's the question we really want answered? I mean, it originally, it predates me, but I know that the origin of this was someone who wanted an opinion on what could a lawyer do to help a diminished capacity client, right? And which was complete walking into a wall, because the lawyer really, well, you can't do the things that you want to do. So anyway, now it's a kind of a different opinion, so, yeah.
Just to add to that, I think the next permutation was sort of, at one point people stepped into, is this just a client file transfer issue?
Right. Well, that's
And now we're
what
kind
it
of
is.
going back into this like middle one, somewhere in between.
Well, I think because of the competency issues, it brings it over into that other land.
We could pull
Yeah.
it, if we wanted to have be a file transfer opinion, then I don't think we should write it fundamentally.
Right, it's
You
not,
know,
yeah.
it doesn't add very much to that footnote.
Right.
And it starts to have value mostly if you're thinking about the other stuff.
So are we
I don't
basically
have, I
trying
think
to-
it's a very fair question, and I
Are we trying to write how do you help a diminished capacity client opinion again? Just coming at it from a slightly different angle.
a much narrower focus.
Right, interesting.
That's what it ends up doing. But how do people feel? I mean, I think we should, I personally think we should be prepared to abandon opinions if they turn out not to be productive. And I don't mind at all, I don't have any personal commitment to having, sometimes authors have a commitment to a particular opinion, but I do not. And so I think people should think about whether they really think this one ought to go out or not.
Yeah, I mean, we do.
Because it's not going to get very different. It's going to get a little more nuanced given what we're talking about, right? And getting into this question of sort of what you do if you think your client really doesn't understand what's going on. But it's not going to change radically. So what do we think?
I think it's going to be helpful for the lawyers that practice in this field to know what to do in this particular ambiguous situation. I mean, that mainly is you've got to verify or have knowledge that this is really what the client wants. I think that adds something to help them think through what to do. I think it's helpful. I don't practice there, though, so I don't know if maybe it's obvious.
I've got to believe it happens to the state lawyers on a regular basis, so it's worthy of doing.
Well, do we think it's worth maybe talking to some of the state lawyers? I mean, I'm more than happy to, call some of the people who do this kind of stuff and see what their gut is, because I'd be interested in that. Okay, Joe?
I understand your point, and indeed, I recognize that we're not really advancing the ball very far from the last time this committee wrote on it. But I have a somewhat lesser opinion of the public's willingness to accept our old opinions and rely on them, and think that some things bear repeating every couple of decades. And this might be one of them, particularly in its current iteration as being kind of short and to the point. So from our point of view, from your point of view, I certainly understand this is kind of boring and not very interesting. But I think that there's...
Not all of that.
Those are my words. You would never ever say that. And in fact, you would never even think that. But I do think that there are some things, just as some topics keep coming up in MCLE over and over again because they bear repeating, there's some basic things that might help practitioners that bear repeating. This might be one of them.
The file transfer point?
Yeah.
Particularly since people resist it.
What's that?
I said particularly since people often resist it.
So it remains a tar baby?
Well, I'm going to go, I guess, I'm looking, I pulled up, I'm thinking about the Bee Gees staying alive. This opinion is like that. But if you, I'm happy, I don't think it's going to be, I can write another paragraph, basically. I think it's another smart paragraph that deals with the question of what happens if you contact the client and it's a problem, and their capacity is a problem. What do you do? And then we'll see if that works for people.
I think that's fair. Meanwhile, we should think about this overarching question, subject to seeing the extra paragraph.
See the extra paragraph and then see what you think.
I do I'm not sure where it'll end up with the 1.14, but if we did get 1.14, I kind of like that we could have an opinion that parallels some of that concept, albeit, as you said, in a pretty specific context.
Right.
Kind of like that, the timing of it. But anyway, yeah, why don't we see what one
So
more
with that
paragraph
paragraph
does,
looks
and then
good.
try to fish it up.
Right. With the waiver idea, the capacity idea, with the parallel to 1.14.
Isn't the problem with our 1.14 that everything hangs on getting consent from the client?
What?
Isn't the proposed rule 1.14, before you can do anything, you have to get client consent before you can take protective action?
Yes.
So,
Well,
here we don't think we can get client consent because the client isn't capacitated.
No, I think the premise would be ultimately that this is a total sort of flyer response to that. But it would be something like, actually 1.14 is designed so that people who normally wouldn't be capable of giving informed consent in the strict sense are able to give informed consent in some way. Right? I mean, the idea here is that people who are really impaired in a way that we would think prevents them from doing certain things in life are still able to do certain things in life. And what's the lawyer's obligation there? And in effect, we'd be saying, all right, that's true for changing lawyers too. Right? For changing lawyers too, there needs to be the ability to take account of the fact that a person who wants to change a lawyer to do something that they have the legal capacity to do, right, needs to be able to give informed consent in a different way. Anyway, that's I think what, and that's where Drew's analogy to 1.14 takes me, right? Something like that.
All right. Anything else? I know it's a little bit early, but I think that's, yes.
Just one very quick question. It's a question for you as attorneys. In reading the draft opinion, as Steve outlined for all of you folks, would it typically trigger a question within the mind of the attorney reader whether they do or don't have reporting responsibilities for elder abuse reading this? Because if the answer is yes, it might be a contribution just to have one paragraph that clarified for the reader that it didn't apply. Because I think the last time I looked into this regarding this opinion, don't quote me on it, but my understanding was unless an attorney works for a certain kind of agency or licensed care facility, the attorney in private practice would not be mandated, as I would be as a healthcare provider. Now, if you think that reading this opinion, attorneys would be wondering about that, maybe just a short paragraph.
I think a footnote might be good.
Regarding that might be some.
There was a paragraph in there when the opinion was sort of focused on the idea of a general rescue.
Yeah.
Right. There was a paragraph that said you don't get any help from the mandatory reporting provision because you're not. My instinct in this streamlined opinion is to, for the flow of the argument, not to go all the way into that, but rather maybe to put a footnote in. I think back in would make some sense.
Yeah, and nor was I advocating that. I just wanted to.
No, I think it's a
throw
really
that out there.
no. I think it's a
To
really
answer your
good
question, there are some lawyers who would ask that question.
Yeah, I think you're absolutely
And I
right.
think you can do it in terms of the permissive without violating the confidentiality. I think, like I said,
I'm very
pattern allows that.
right. I'm going to be interested. I think Drew's idea of looking at 1.14 is actually really helpful in this situation because it's a framework for dealing. It suggests a sort of approach to this kind of problem, which is definitely not a reporting approach. It's a process-based approach.
I wonder, I have a question, I'm not sure it's an appropriate question, but my personal view of all the rules that have been submitted to the Supreme Court, I think 1.14 is one of the more likely to not be adopted by the Supreme Court. And if that was the case, I wonder what this group's thought is, and it may be where this is going, to use the analysis of 1.4 in the form of an opinion in order to provide that guidance. So if the committee concluded that the guidance in 1.14, and it could be drafted somewhat differently to fit well into an opinion, but to still capture and use and provide some utility from what was drafted in 1.14 as quote-unquote guidance in an ethics opinion.
I think that'd be a great idea if 1.14 doesn't pass.
Right.
Right. And if it, but I wouldn't put too much effort into it unless and until we think.
Absolutely. No, I just something to keep in mind. There. I think that would be a way to save the opinion and save some of the information that's.
Maybe we can finish the opinion and put it on ice until we know what happens.
Yeah, so we're gonna, once it's done, we're gonna wait and see. All right, anything else? All right, well then, we'll adjourn a little bit early today. Thanks, everybody.
Thank you.
Good job, Drew.